Was wondering if everybody would please stand and join me for the Pledge of Allegiance. We have Agenda Item A, Jeffrey Russell, Case 15-545. County Please.
Your Honor, this is a motion to vacate the order imposing penalty, and the order in the county's recommendation contained an incorrect fine amount, so the county's recommending the magistrate grant its order to grant its motion to vacate the order imposing penalty issued on September 7th, 2016.
Is Mr. Russell present? There being no response, the motion is granted.
Thank you.
Take us to, yeah, I'm going to take it. Agenda Item 8, Consent Affidavits. The first case we're going to call will be Agenda Item 6, CCS TTT Inc. This is a case that I have a conflict of interest, so Mr. Wilson will take it from here.
This is case number COD-14-01-292. Is anybody present for that case? Since we pulled the item, you want to go ahead and review it very briefly? Got to make you talk, man.
Yeah, Charlie Bush. Charlie Bush, Certified Code Compliance Officer of Charlotte County. We have an expired single-family permit that expired January 17th, 2016. This is a second fine.
Has there been any communication whatsoever?
Not at all.
Okay. I'll accept and approve the affidavit as stated.
Thank you.
That's it?
That was easy.
Thank you, sir. He earned his pay for the day.
Glad I could be of assistance.
Okay, thank you. Thank you, Mr. Wilson. All right, continuing with agendas, let's go to item number 25, Michael and Jennifer Bertel, case 15-2752. And counsel, would you announce your appearance for the record, please?
Jim Getz, and I'm an attorney, and I'm representing Nation Star Mortgage, LLC.
We need it.
And
all right, well, we'll go have the county proceed, and then we'll take the response. Okay. County's ready.
Officer Leonard.
Rhonda Leonard, Certified Code Enforcement Officer, Charlotte County. This case was before you originally, February 3rd of this year. This is the third affidavit of noncompliance. We had to have the grass cut again.
All right. Anything further from the county at this time?
Nothing further.
Mr. Getz.
on this, we have a sale date. This sale has been canceled, and I've spoken to the code enforcement officer regarding this, but we have a new sale date. Hopefully we can get everything sold by December the 14th, 2016. I've been just notified that this property is vacant. I was under the impression that it was not vacant before today's hearing. We are working to try to get someone out there to mow the grass, to do some maintenance, but there's a lot of other maintenance that has to be done on this, and hopefully we can work with the code enforcement. Well, we have been working with the code enforcement people to try to get this rectified, get the property back on the market as soon as possible.
Sure, I understand. Anything further, sir? Yeah. All right. Being that this is for past violations, I'll go ahead and accept the affidavit as stated. We've noted the file on the December 16th sale date, and hopefully we can get this thing sold and back into shape.
Hopefully I don't have to come back again, even though I appreciate being here.
Okay. Thank you, Mr.
Thank
Getz.
you.
What are we doing next?
2596.
I'm sorry.
Yes, I didn't circle. I'm sorry. 11, then 26, then 26.
Okay. Let's go to the affidavits. Agenda item 11, Fetlar LLC, case 14-2596 COD. If you're present on that case, please approach and announce your appearance, please.
Yes. Bill Axelgard. I represent the ownership group, a contractor that does some of the renovation work for them, asked to remedy the situation on the issues there.
Okay, and you were hired by the corporation to do that? Okay. The way we'll proceed then is the county will go first, and I'll be happy to listen to any response that you have, okay? All right, the county's ready to proceed. Please call your first witness.
Officer Leonard.
Rhonda Leonard, Certified Code Enforcement Officer, Charlotte County. This case was before you on September 2nd, 2015 for no permit on a pool pump that was installed, and due to the electric does require one. This is the third affidavit. It is a one-day fine. They have since gotten the permit and gotten it inspected and passed, but at the time that we filed this, they still did not have a permit for it.
Okay. Anything further from the county?
Nothing further.
Yes, sir.
We've completed everything that we were told was the problem, and so hopefully everything's remedied and we can go ahead and pay whatever fines are due and be done with it.
Sure. You understand that when we have these kinds of issues, they're actually for things that occurred in the past.
Correct.
It's great that everything's back into shape, but what I'm going to have to do is affirm the affidavit is stated because it is a past violation. Okay.
I understand.
And then you can see the staff if you need to take care of that, or if the owner's going to take care of it.
They've been very helpful and
Okay. Thank you for your appearance. Have a good day, sir.
Item 26. 26.
Let's go to agenda item 26, COD 152795, Robert and Ann Buchholz. If you're present, please approach. Your names, please. And your name?
Robert Buchholz.
Yes, sir. The way we'll proceed is just as you've seen previously, the county will go first, and then I'll be happy to listen to any response that you have. If you just bear with me 1 second. Okay, if the county's ready to proceed, its first witness, please.
Officer LaRue.
Chris LaRue, Charlotte County Code Compliance. This investigation was originally conducted by Officer Reinwald. It was opened on October 22nd, 2015 for a complaint of junk-like conditions and an unregistered boat. On that case, a notice of violation was served in accordance to Florida Law 162. The case was brought before to hearing on May 4th, 2016 for the violations of junk-like conditions, prohibited use of the property, parking of boats, recreational vehicles, trucks and trailers, along with International Property Maintenance Code violations of responsibility and accessory structure. A new complaint was received at this location on September the 7th. I conducted an inspection on September the 8th, finding junk-like conditions consisting of, but not limited to, an inoperable vehicle in the driveway, a boat with expired registration, jet skis in the backyard that appeared to be inoperable, 2 of them on the ground, and some other items creating a junk-like condition and a prohibited use of the property. I met with the owner on that occasion, did not issue a notice, an affidavit of non-compliance at that time to give the owner some time to go ahead and work to correct the violations. I conducted further inspections on September the 12th, September the 19th, and September the 23rd, which was the day the property was abated. This A&C is a one-day fine with an abatement cost for a total cost of $563. That concludes my testimony.
Thank you. Anything further from the county?
Nothing further.
Mr. Buchholz, your response, please.
On the original violation that he's quoting of September of 15, the case was dismissed. I have a letter from that. When he did come back on this recent violation, I had talked to a code enforcer in May that had written this back up, that according to him is documented that that's what the original violation was for. It was May 16th, I believe. Let me find the paperwork here. But and that at that time my wife had met particularly because I am working during the daytime, and then she had met with the man many times over many years now. And each time that we meet with him, I have the violation sheet. it gets closed. It's either closed prior to when we do it or after we shortly talk to him. I immediately start trying to comply to whatever he's wanted to make him happy, so I don't have to meet yourself in this circumstance. From the day one I bought the house 4 years ago, I've been called from the first day by some psychotic neighbor that continually calls on me. I've had permits for the various different projects, from driveway permit that I put in because of the prior officer said I had a trailer in the yard that could not be parked there, and his suggestion was build a driveway, so I expanded my driveway. Each and every time I have tried to comply to this man, to the psycho neighbor that I have that calls continuously on me. My son mows the lawn once a week, every week. I've burned up 3 lawnmowers, 3 weed eaters in 4 years. Periodically, the weed does not get trimmed around my boat. My cars are licensed every year. I made a mistake. I didn't get it licensed until May when he noticed me. I did license it immediately. Then my son lost the stickers. We went and paid again to have it licensed a week later to have them licensed. I talked to this man. My wife talked to him initially.
The code enforcer came by and we talked about rectifying the situation. We walked in the backyard. We looked at the jet skis and we agreed that a 6-foot privacy fence would be a good way to rectify this situation. So I have receipts for the lumber, I have receipts for the permit, and the fence was to be built, but the day before the fence was to be built, the jet skis were taken from us. Our personal property was taken from us. The first day that the code enforcers came by, they said, listen, we know you've been working with a previous code enforcer. Unfortunately, that man has passed away, and the things he told you that would rectify these situations are not good enough. So now we want you to do this. And I said, well, 10 days is a very short amount of time. My husband works all day and doesn't get home till dark. He said, ma'am, don't worry about that. As long as we see progression, we're not here to be bad guys. As long as we see you working with us, don't worry about this time frame. So at that point, we talked about some cars in our driveway.
They took the pictures.
Okay, you have the pictures, I guess,
Of
because
the
we have
abandoned
pictures.
vehicle that the gentleman said, which according to your front page of your website says that you can have one unlicensed vehicle that appears to be operable.
And as you can see from the pictures.
The pictures they have will show you the vehicle is very good looking vehicle. I drove it home from the person's house 3 weeks prior to them taking the vehicle.
It's section 3-9-76, option B, a single unlicensed motor vehicle which by outward appearance appears operable is permitted to be parked in the driveway.
And I had just purchased the vehicle 3 weeks prior. I have a receipt from the gentleman that I purchased this from. The vehicle is from Canada. I've been waiting for a title to come from the man. I tried to explain this to the gentleman multiple times. 2 days before he took the vehicle, I told him I was going that day to buy the materials. Since I get paid once a week and I support 4 kids and pay college tuition, I can't immediately jump out and spend the money that I wasn't prepared to spend.
So we have receipts for the permit and receipts for the lumber, and the lumber was stacked right by the jet skis.
Next to the jet skis.
They had to have seen the progression
They
that
had
we
to
were
walk by
trying
it
every
multiple
weekend.
times. They took
It's kind of hard to follow when you're both talking at the same time.
They took my wheelbarrow and threw it across the yard and physically bent it. I have a picture on my phone of it. They ripped the covers off of the 3 jet skis they did leave there. They ripped them off and let them flapping through the yard. Everything that they did was pick up 2 jet skis, one I've had for 20 years and have ridden from California to Florida and everywhere in between. I raced it for 3 years professionally. They took a vehicle I've owned. Yes, it was not registered in the state of Florida, but it was owned and licensed in Colorado where it came from. It has my feet molded into the hull of the ship for doing the tricks I do. The man did not tell me 2 days prior when I said by Friday night I'll have a fence built. The fence was laying there. I had a vehicle that I have a bill of sale for that I believe is 30 days in Florida to be able to license it or get it registered. I didn't own it for 3 weeks. I tried to explain to the man. The prior code enforcement was a very well-spoken, very understandable, and could understand situations of somebody calling from the very first day I bought the house. Literally, I have sheets. It wasn't even in my name yet. It was still in the company that had repossessed it. They have harassed me during inspections. While I'm inspecting a driveway standing with an officer, he passes my inspection. Within an hour, he's back. So the person has called him saying I'm doing improper things, and he's there to try to find out what I did wrong. This guy has harassed me countless times. I don't know what else to do. We comply every single time. It's closed every single time. The one prior letter that was sent out, it was closed. I have the letter. I don't understand what this issue is. This man is the most unreasonable. I would never give this man a gun or let him be a cop. He'd be the first one to shoot somebody. He has no justification for this at all.
We were doing what we were told to do.
I fixed the car to get it to where I could move the trailer that was in the backyard that weekend. The very first thing, I didn't even have the car's bumper on to get the car finished. I pulled in the backyard, moved the trailer where he wanted it, not where the prior inspector wanted it. He wanted it over on the side of the house. I then mowed any other spot that he wanted. I don't know, I borrowed a weed eater to weed eat areas that might have been slightly ungrown around the house. But the lawn is mowed every Friday by my child. I pay him every Friday. I don't know what more I can do to appease this man.
I understand. Response from the county?
Yes, I'd like to note that high grass is not part of the affidavit of noncompliance in this case. Also, Officer LaRue, do you have pictures from September 2016 that show the date of the conditions of the property on the date it was abated?
I do. I have pictures starting back on September 8th when I started my investigation.
Okay,
To the
does fairly and accurately depict the...
They do, sir.
You want to show them to
I've seen
Mr.
the
Mrs.
pictures. I don't need to see them. He just showed them to me.
Do you have any objection to me admitting those into evidence?
I don't know what I can do otherwise, sir. I mean, I'm going to have to obey by whatever you say. I just find this that,
I understand, sir.
when the vehicle, you can see the black vehicle that he had, the jet skis are in the exact location that the prior inspector had, but the pictures that they're showing have the covers that have been torn off that were tied to the vehicles. The engine that is sitting on the front ground was the engine that I pulled out of the vehicle to swap them over, which they were told in advance that this is what the vehicle was purchased for. It was to fix the other vehicle. The engine was sitting on the ground because the engine hoist is a metal-wheeled vehicle that one of the wheels got off, and the engine fell into the yard. It rained for 2 days solid after I did this, and I immediately got it out, drug it out of the yard because he had said, get it out of the yard. So I got it out of the yard, put it in the driveway, and started to disassemble it. The gentleman said anything that was in my car that I took out and put, that he didn't like where it was, I put it into the car. He said, that didn't fix the problem. I said, well, it went to the car. I put the motor back in the car. He said, that didn't fix the problem. I said, it went to the car. I mean, how can I take it off the ground and put it in the car? Where else am I supposed to put it on? I have no garage.
We just don't understand why the car is towed. I mean, the pictures show by outward appearance,
Granted,
appears
I
operable.
had a power washer for one night there because I cleaned my driveway to make them happy. It has a cherry picker there because I was returning the cherry picker that I had bought, which is the engine hoist, that I had borrowed from someone. I have a neighbor down the street. I have pictures. He has car trailers in his yard, RVs in his yards, boat trailers with 3-foot grass growing through it in the right-of-way of the subdivision. It's been that way since the day I bought my house.
And yet we get harassed.
There's a car on the ground, physically laying on the ground with 6 covers over the top of it and the plate laying on the back of the vehicle 6 houses away from mine. My neighbor's grass around has been 3 feet tall. They don't get called on. But for some reason, this man feels that I've done something inappropriate, and each and every time. The law allows me 10 days to work on my vehicle. The original violation that it says it was on a jack stand, I had the struts out, putting new struts in. I have 10 days, according to the law that I know of, by what I've read. I have 30 days to license the vehicle. I owned it for 3 weeks.
So we can't get to the vehicles because we don't have a title, and all his tools are in the truck.
Yeah, I lost
So that's
$500 plus worth of
hundreds of
Snap-on
dollars.
and Cornwell tools that were sitting in the front seat of
And
the
all the
vehicle.
car parts are
And
now
all the
unavailable
car
to
parts
us.
that were going to be put on the car, or the reason why I purchased the vehicle, are now in a salvage yard that they won't give me any of my stuff because I don't have the title to the vehicle. I'm not going to title a vehicle now that I can't even own.
All right, now, I understand your level of frustration and that you feel like you've been pushed around on this thing, but I wanted to ask you a question. On those photographs, what we're looking at is Officer LaRue testified that those pictures show what your property looked like on September 23rd, 2016. My question to you, that's what we're focusing on, and I understand that, you know, and I don't blame you for being upset, but do those pictures show what your property looked like on September 23rd, 2016?
Those are dated the 12th. The cherry picker was gone. We cleaned up the driveway.
The 23rd, this one might be. Well, this one would be, I
Well, here's the
guess.
23rd. That's a picture of them towing it away.
Well, this one's dated. That's what's the 12th? That one ain't it.
Right.
This one would be, that's them towing it away.
So just the pictures dated the 23rd, is that what you're asking about? You're not asking about pictures dated the 12th?
No, I'm looking at the 23rd of September.
These are, yes. These,
Okay, so
Other code enforcer before this one told us to put the jet skis in this area and cover them with the blue tarps that you see here on the ground.
okay, so those pictures that you have in your hand, Mrs. Buckholz, accurately depict the conditions in the property on the 23rd of September of this year?
Yes.
Okay, now, Sean, would you put those together for me and bring them up here? Leave those top two on the top, if you would.
23rd.
Top two on the top.
And we'd like to offer those photographs and evidence.
I'm sorry?
We'd like to offer those photographs and evidence.
Yeah, that's, I presume that it would be, so.
But I will say that the tarps and such that are on the ground, yeah, that they've thrown them to the ground. That the wheelbarrow was not on the ground like that, and the tarps were on each one of them, and all the jet skis had covers on them.
And conveniently enough, you can't see all the building material because that's now a 6-foot privacy fence, as we discussed would be the
And
situation.
he would be actually to the right of that truck, right next to the boat. It was actually leaning against the boat where they made
All the building
asked us
materials
to
for
move
the
the boat.
fence.
Okay.
And all those jet skis and trailers are behind it. There's the truck. And
It appears operable.
It appears operable. It appears to be a nice vehicle. The one that's upside down there is raced from the one country to the other. It's been literally in front of every monument we can have water in front of.
Okay.
There's the engine that wasn't supposed to be put back into the car that I was told that was evading the problem, putting the vehicle back into the car. The motor back in.
Response from the county, please.
Officer Liu, could you describe the conditions as you observed them on September 23rd?
Yes. As the photos are showing, the picture that's up right now, the vehicle is not operable. This picture is taken through the grill of the vehicle, and I'm not denying that he took the motor off the ground and put it in the engine compartment, but if a radiator was there, I couldn't see the motor, so therefore it's not operable. You can see a hose area.
Please, just one at a time.
A hose area that has no hose even connected to it. So the vehicle was not operable. The tires may have been aired up, but it was not an operable vehicle. Wasn't the entire time, because the wife told me when I first went there that they'd purchased the vehicle to put the motor in it in another vehicle. And then they were going to do something either with scrap or get rid of that black Durango.
Just said all that.
So,
All right, so
but the pictures that are before you, sir, represent what I saw on the 23rd of September. The jet skis that were in back, I believe maybe possibly 5 jet skis total. The only 2 that were taken were the 2 that were not properly registered. The other 3 did not appear operable, but since they were properly registered, they were left. Those photographs of those jet skis, if I could brought in the photographs from the finding date, are exactly in the same condition that they were on October the 22nd, 2015, when Officer Reinwald was out there investigating it.
As we said, this is not a prior case, sir. We're discussing current
Did we
events.
not talk about a fence rectifying the situation?
And did you not yourself and the other gentleman there agree that this was a proper fix? And did you not, 2 days prior, be told that I was going that night to purchase this stuff since I got paid on Friday? I was going...
Here's the receipt.
The receipt, and was not the fence material completely
Leaning up
concrete,
against right there?
poles and fencing, pre-built fencing, leaning against the boat? Was it not sitting there? And that on that same day, did we not have an exceptionally long conversation of what would make you happy and stop
If I can, sir.
I believe that was...
We had an extensive conversation on September 23rd after the property was abated. I never spoke to this gentleman prior to the 23rd. I dealt specifically with his wife. So I never had any contact with him.
sir, I will bring up...
Did you say a
Please.
fence was a good fix?
Mrs. Buckholz, please, I can only hear one side at a time here, so if you're yelling at each other, it's kind of hard to follow. Mr. LaRue, Officer LaRue.
I would be glad to go to my phone records
Just hang
and
on
pull
one
up the conversation on my birthday that we had about what would make you happy and what would make you have no problems with the situation. I will be glad to bring up the hours
Durango ever mentioned?
of how long we talked and what you expected me to do. You told me that I needed to remove a power washer. The power washer, I had already said, was already removed. You told me to get rid of the motor. The motor had been removed, and I put it back into a vehicle. You told me the things that you required. You just lied and said that you didn't talk to me, and I will be glad to go on my phone to my phone records and show the minutes of how long we discussed, you and I, from my shop that I work in. So you just lied to me saying that you didn't talk to me prior to the 23rd.
Sir, I don't
All right,
remember.
well, okay.
I'll be glad to bring it up on my...
Ladies and gentlemen, please, okay? I've got to maintain order here. If you want to snipe at each other, that's not for this hearing today.
Does not speak the truth or hold behind his speech.
Sir, I understand. For procedural reasons, I'll go ahead and admit the photographs as Charlotte County Composite Exhibit 1 into evidence. I think I've heard sufficient evidence on this, and while you folks have obviously had quite a deal on your hands, and there may have been some confusion between Mr. Reinwald's initial comments and then Officer LaRue's follow-up on that. The focus of what we're here about today is on the September 23rd, 2016. These photographs that you have confirmed show the conditions of the property on that date. And in light of that admission, in light of the codes, I'm going to affirm this affidavit as stated. I know you disagree with that, and you know when you have the right to appeal that.
I figured it was going to go that way, sir.
Well, sir,
It's just that's how it goes. I understand you have a job and that it was going to be stated this way, but at least I got to speak the truth and someone else got to lie. So whatever you say, sir, I'll be glad to take care of, just like I always have tried to comply with the law.
yes, sir. Okay, thank you, Mr. and Mrs. Buckles.
Unlike some lying people.
Number 36.
36. Excuse me? They'll help you right over here. Can you get somebody to explain? Okay, he's got it over there. Okay, thank you. Let's go to agenda item 36, COD 161364, Stephen and Leanne Akin. If you're present, please approach.
What about my vehicle and tools? How's that, sir?
Okay, well, I'll just...
What about my vehicle and tools? Can I get my tools out?
Sir, they'll take care of that out. No. Okay, your name, sir?
Stephen Akin.
Okay, thank you, sir. We'll have the county go first, and then we'll give you time to respond, if you would. County, ready to proceed?
Officer LaRue?
Chris LaRue, Charlotte County Code Compliance. This is a case that was started back in April of 2016 regarding junk-like conditions and a garage wall that is separated from the garage. The finding of facts is dated August 4th, 2016. I re-inspected the property on September the 8th for a first affidavit. Property was still in violation with junk-like conditions and a garage wall that has separated. Again, this is a one-day fine of $60. I have no further testimony at this time.
All right, so this goes back to September 8th of this year?
Correct, sir.
Okay, thank you. Is it Mr. Akin?
Yes, sir.
Akin, I'm pronouncing
You
it
did
correctly.
well.
Okay, thank you. You heard Officer LaRue's testimony. What is your response, sir?
My response is this is ongoing targeted harassment. I'm sure that's kind of the gist of these scenarios, like the previous gentleman that was up here. This goes back as long as I've owned the property, back to 2008 when we initially bought it. Charlie over here and I have been not friends, but dealing with several issues, several complaints from that time on. I'm a general contractor. I had tractors there, trailers, those my dog barking, just everything and anything in junkyard-like conditions. And those photos, that's what it's looked like all summer. I threw my hands up in the air. I've been dealing with this, and usually when Charlie was the enforcement officer, we'd talk on the phone, he'd tell me what to fix. He always tried to keep things civil between my neighbor and I, but by insisting, oh, it's a guy driving by. I don't know if you want to see these, but last night I went driving around. You'd have to drive past at least 15 on my street, on Beacon, or the rear of my property, at least 15 properties that are way out of compliance. And because I've had such a long history with code compliance, I know about RVs not supposed to be hooked to utilities, more than one boat or trailer combination, junkyard-like conditions. You know, on that street alone, there's 20 cars without tags. The property that you're looking at is not within the triangle of visibility from my street address. It's a separated garage behind the home. The issues that Mr. Bush and I settled a long time ago include permits that were not mine. They were there from previous people. We settled him. He was going to give me complimentary or courtesy inspections from the building department. Thought it went away. It didn't. For a lift station, that there had been no work done. Previous owners. But anyway, it's a long history, and this shows the property in 2015, which is when it started up again. I would have issues. Charlie and I would work it. I mean, if I work in my yard or in my driveway, changing my oil, he would get a call. Been out several times, and every time I attempted to remedy the issue, and then I realized it's never going to go away. Those permits from Hurricane Charlie where the county would not come out and inspect, there's a $4,500 lien they put on my property. That, with fines, it makes it, now my neighbor has me as a neighbor for life. I don't have enough equity to do, to ever move. So anyway, I've tried at different times to pursue it civilly as a harassment suit, but even though the Sunshine Law applies, it's always anonymous. There's never a face, unless you're here, there's never a face to the complaints. And it's selective, in my opinion, because you have to drive past all of these other properties and disregard them to come harass me. And a neighbor, an old grouchy man, is, I hate to, anyway, is using the county as an instrument for harassment. And this goes back, and if you'd like, Mr. Bush to, respond to this, 7+ years. And until this summer, after you guys, the code enforcement put a lien, how I found out I had a new person, got a letter cleaned up the yard, took these photos, asked...
Would you like for me to see those photographs?
Yeah, sure.
If you would, please show them to the county first, and
First person here?
if you would, please.
That was when all the permit issues came up. When I would address an issue, they would find something else. I'm of the opinion now, I do want to settle this, but the fines and whatnot, it's a homesteaded property, the taxes are current, so I'm stuck there forever. I do want to fix it, but this summer I locked the gate and never went back there. Let the grass grow, I just said, heck with it. And now I'm of the opinion, if you can't beat them, join them, and that's the photos in about 15 minutes before sunset last night. From the triangle of visibility from Beacon, I've found countless violations that nobody's addressing, just me.
Sure.
So I feel like now I'll just do the same thing, except for in the issue of transparency, I won't hide. I will personally sign every photo that I send you guys as a complaint, and they can just work harder. But I do want to settle the issue, and whatever needs to be done will be done.
If you will excuse me 1 second, does the county have any objection to me reviewing those? I know they appear to be dated after the incident, but...
Your Honor, the first couple are dated from 2015, and to the extent that they depict other properties, they're irrelevant.
Okay. I'll give it the weight that it deserves, and but I'll go ahead and admit those as the respondent's composite exhibit A, we'll call it. If you would.
Mr. Siegel, if I may, they're really not evidence. They're just, I'm trying to show
I understand.
that.
Mr. Hagan, one of the things I'm concerned about is that you're raising the issue of selective enforcement, and to do that, we have to hear evidence that at the time of your instance that the county knew about other violations and selected or elected not to enforce those and had some motive to enforce it only against you. So these photographs probably, I think counsel was right, wouldn't be relevant as to that time, but it helps me to understand what you're telling me if I can at least see the property. And all I have in front of me right now is an affidavit.
Yes.
And here's what this affidavit says. It says that you haven't complied with the with my order back in August 4th, 2016. And then they say that they came back on September 8th and that the conditions hadn't changed. And so they're seeking a $60 fine against you. And certainly I can understand why you're upset with this. I haven't heard why you didn't comply with my former order on August 4th. Is there anything you want to talk to me about that?
I had received so many notifications over the years, I decided once there was the $4,500 lien put on my home for a roof I didn't put on that you guys wouldn't inspect from 2004, a Hurricane Charlie home, that I was just done with it. And it's petty, but I decided if the neighbor wants to make such a big deal about it, he can I'll let it go to seed. And I would like to contend, when you said about selective enforcement, and maybe we need to bring Mr. Bush up, he's very easy to talk to and always trying to keep the peace. But he specifically told me when I pointed out other properties, when he was at my property, we don't go looking. We're plenty busy with complaints. We do not go looking for these. We only respond to complaints. So in my opinion, if you don't universally apply the code, it's not fair. And I know this may be something for another day, and I didn't realize the formality of this meeting, and maybe I should have counsel, but I don't know. I do want to settle the issue, but I do want you to understand that this has been 7+ years, and this year I just said heck with it. I'm beyond it.
All right. Well, they're seeking a $60 fine, and part of me wants to dismiss this thing, but you can't just blow off these things. And you had that prior order of May 4th, and that wasn't complied with, and that's unfortunate. I'm going to affirm this affidavit, but let me encourage you to do something, and that is, please don't blow these things off. If you've got a problem or something, call the code enforcement people. They really will work with you.
Can I add? I'm sorry to interrupt.
No, go ahead.
We were in communication. He was the gentleman in red. I don't know him too well. And the date that those pictures that where the property looks nice.
Yes, sir.
That was the date we've got, and I think it was even over a year ago. But I called Charlie. I have a cell phone number. I said, "Hey man, what's going on now? I have photos. I'd like to email you, show you it's all cleaned up." "No, you're not. I guess they rotate out. No, you're not in my, dealing with this gentleman." And I came up to the county, tried to fix a couple of issues. Well, anyway, that's neither here nor there. I'm sorry, I lost my train of thought. That's all right. We did. Sorry, I'm very nervous. We did work with this gentleman, and we asked for an extension, saying we don't have the time or money to do anything about this now. Started cleaning up the yard. He came back a few days later to tell us it doesn't matter what you do if you don't fix the delaminating stucco on the side of the house where the stucco's coming off the home. If you don't fix that, it doesn't matter. It's all or nothing. So, and that's the point where I threw my hands up when he said, it doesn't matter how clean it is, if you don't fix the stucco wall, then, there's no, what I heard from that, and it probably wasn't the way he said it, but don't bother doing anything if you can't do it all.
If there hadn't been this prior violation of my previous order, I probably would have dismissed this thing. But because of that, and, I understand you've got a predatory neighbor, and that's truly unfortunate. There may be some things you might want to ultimately contact counsel or something like that. But because you, by your own testimony, kind of blew this off, and I understand you've got...
Well, I want to be honest. It is what it is. I'm sorry to interrupt.
No, that's fine. Go ahead. I want you to be able to speak to me.
Well, I've pretty much said my whole piece. It's been a long road, and with the lien that was put on my house for a detached building's roof, the equity isn't there to ever move on, and it just became a point of futility to do much. And my question would be, when you say a $60 fine, you mean $60 per day from the date of your August 4th order?
$60 fine.
Oh, well, that's fine. I'll pay the $60 fine. I had read some of the things that were sent to me said things like $250 a day.
Those are other cases. You're not here about those.
So there's other pending cases?
If I could for a minute, please, Sean Horton, Charlotte County Code Enforcement. The notice of violation explains that if you don't take care of a problem, you could incur fines of up to $250 a day for each day the violation exists. That may be where he read that. This first affidavit has started out as a $50 fine with a $10 filing fee, and that's what it's been from the beginning, and that's where it shall stop if the order is followed. But we have to follow, and Mr. LaRue, whether it was conveyed properly or not, Mr. LaRue did convey the proper message in that all the problems have to be fixed. Your order was that these problems have to be taken care of. So if one thing out of three is still a violation, we are following the order that was set before us.
I'll offer on the affidavit in the amount of $60. Okay, Stacy?
So just pay a $60 fine and fix things?
Yes, sir, but that doesn't, you've got to make sure your house is in compliance, okay?
Yes, sir. Could I ask them, though, is there anything else pending? I assume there was multiple issues.
See all these people behind you, I've got to call these people.
No, I know, but I would assume that I'd have a file with you guys for all these.
I will talk to him.
Okay, yeah, Mr. Officer LaRue will meet you.
Okay, thank you. I appreciate your time.
Thank you, sir. Who do we have next?
The man who wants to testify, wants to testify here. And now, do you want to hear him before we start business? Or are you going to wait until before we start the case?
I would prefer to do it with the case so that if I hear it piecemeal, then I think, unless he's got some kind of urgency that he has to be somewhere else, then I...
All right, and we have one more that I have to circle.
Okay, so then...
All right, so then we'll go to new business, and So we need to approve the rest of the affidavit.
I do. There's no one else here. All right. With regard to the consent affidavits, the remainder will be accepted as stated. Excuse me.
New business.
Okay, we're under Article 9 of the agenda, old business. There is none, so it takes us to new business. We're going to go to agenda item M, as in Mary, Department of Health case 15380, Tina Halsey Perez. If you're here in that case, please approach. If the county is ready to proceed, please call your first witness. I note that no one is here on behalf of the respondent. Officer Brown.
Stephen Brown, Certified Code Enforcement Officer for Charlotte County. 19399 Edgewater Drive is zoned RSF 3.5. The owner of record is Tina Halsey Perez. The case was initiated by me on April 27, 2016, after receiving complaint from the Department of Health that the owners were in violation of the inspection and pump out ordinance. During the investigation, I took a photograph of the property on April 27, 2016. This photo fairly and accurately represents the conditions I observed. I would like to offer the photograph and the evidence as County Composite Exhibit 1.
That will be marked as Composite Exhibit 1 and admitted into evidence. Please proceed, Officer Brown.
I have not had contact with the owner. The notice of violation was served in accordance with Florida Statute 162. As of November 1st, 2016, Department of Health verified via email that this address is still not in compliance. This concludes my testimony. I have Brian from the Department of Health that will confirm.
Okay. Yes, sir.
I'm Brian Arbeiter, Environmental Specialist 2, Florida Department of Health. I'm the custodian of the DOH records in regard to this database. Reviewed records for 19399 Edgewater Drive on November 2nd and found that no permits pertaining to the inspection and pump out ordinance have been issued within the last 5 years.
Anything further, sir?
Nope.
Anything further from the county?
The county recommends respondent be found in violation of the code sections listed in the notice of violation, and from the date of this order, 30 days to have the septic tank pumped and inspected in accordance with Charlotte County Code, or thereafter face a fine of $50 per day for each day a violation exists.
Thank you. In Charlotte County versus Tina Halsey Perez, Department of Health case 15380, pertaining to parcel 4022229204014. I find that the unrefuted evidence establishes the existence of the violation set forth in the notice of violation. I'll accept the county recommendation as my order.
Thank you. Your Honor, tab L is also a Department of Health case.
I'm sorry?
We're doing L now.
Tab L is also a Department of Health case.
Okay. Yeah, let's go to, let's see. We'll go to agenda item L, case DOH 15369, Onita Havia. If anyone's here on behalf of the respondent, if you would please approach the podium. I note that no one is present on behalf of the respondent, so if the county is ready to proceed, its first witness, please.
Officer Brown.
Stephen Brown, Certified Code Enforcement Officer for Charlotte County. 926 Hood Avenue is zoned RSF 3.5. The owner of record is Oneida R. Hevia Estate. The case was initiated by me on April 26, 2016, after receiving complaint from the Department of Health that the owners were in violation of the inspection and pump out ordinance. During the investigation, I took a photograph of the property on April 26, 2016. This photo fairly and accurately represents the conditions I observed. I would like to offer the photograph and evidence as County Composite Exhibit 1.
So marked and admitted. Please proceed.
I have not had contact with the owner. The notice of violation was served in accordance with Florida Statute 162. As of November 1st, 2016, Department of Health verified via email that this address is still not in compliance. This concludes my testimony. I'd like to ask Brian from Department of Health to come back up.
Please proceed.
Brian Arbeiter, Environmental Specialist 2, Florida Department of Health. I am the custodian of DOH records in regard to this database. I reviewed records for 926 Hood Avenue on November 2nd and found that no permits pertaining to this inspection and pump out ordinance have been issued within the last 5 years.
Thank you. Anything further from the county?
The county recommends respondent be found in violation of the code sections listed in the notice of violation, and from the date of this order, 30 days to have the septic tank pumped and inspected in accordance with Charlotte County Code, or thereafter face a fine of $50 per day for each day a violation exists.
Thank you. Charlotte County versus Onita R. Havia Est, DOH case 15369, parcel ID 40222-0403016. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation, and I will accept the county recommendation as my order. Did we remove in from the agenda?
Yes.
Okay,
Well,
thank you.
it's not removed, it's just not, there's nobody here.
Oh, okay, that's just a corrective thing. Okay, so that takes us to where?
C.
I'm sorry?
C.
C? Okay, that will take us to agenda item C, case COD 16-1525, JABE, Inc., Anne Marie Peterson and Michael, well, I'm not going to butcher his last name. I note that the county wishes to dismiss Anne Marie Preston, Michael Kansanowitz, and dismiss sections violations for 3-95B, 3-933E, and 3-9-76.
Yes, Your Honor.
Okay, those will be dismissed as with those parties. If the county's ready to, I'm sorry, your name, sir?
I'm Jason Birch, owner of JB Inc.
Okay, thank you. We'll proceed with the county and then we'll come back. If the county's ready to proceed, first witness, please.
Officer Leonard.
My name is Rhonda Leonard. I'm a certified code enforcement officer for Charlotte County. 3373 Edge Hill Terrace is zoned RSF 3.5. The owner of record is JB Inc. On May 17th, I conducted an inspection finding the following violations of outside storage of miscellaneous items, including furniture, appliances, buckets, waste containers, cabinets, and assorted other debris. During the investigation, I took photographs of the property on July 11th, August 2nd, September 9th, and October 26th. These photos fairly and accurately represent the conditions I observed. I'd like to offer the photographs into evidence as County Composite Exhibit 1.
Yeah.
Sir, do you have any objection to me admitting those into evidence?
No, sir.
Okay, thank you. Those will be marked as Charlotte County Composite Exhibit 1. They'll be admitted into evidence. And just a reminder, if you have anything that you want to offer to evidence, we can take it when we come to you, okay? Please proceed, Officer Leonard.
A warning letter was sent to the owner outlining the violations and allowing 10 days for compliance with the listed violations. I spoke with Mr. Birch on May 20th. He advised me he was foreclosing on the residence and would be needing more time. I granted a 30-day extension. An inspection on July 11th found a large pile of debris at the curb. Waste Management was notified. There was still debris in the yard and a broken window. Search of the clerk of court found a Liz pendants recorded July 5th, but I could not find the agreement for deed. A 20-day extension was put in. I spoke to Mr. Birch again on August 16th. He said he had a court date at the end of the month, would be receiving writ of possession. He said he had a crew set up to clean up the property. Another extension was granted. On September 9th, I received an email from Charlotte County Sheriff's Office regarding electric being off and FPL had been called out to disconnect. I inspected the property with Deputy Miller, finding the right-of-way in disrepair, outside storage of wood, pipes, appliances, glass, pallets, buckets, blocks, trash, sink, TV, metal poles, fan, and sort of other items, broken windows, damaged exterior door frame on the garage, exposed wiring at the service panel, jumper cables connected to the electric wires at the riser, a light switch burnt, the interior was not being maintained in a clean sanitary condition, the garage was being used for living purposes, no water or electric service to the residence that was being occupied. I posted the property unsafe and unfit for human habitation. A search of the clerk of court found a final judgment with a writ of possession to follow. The notice of violation was served in accordance with Florida Statute 162. Respondents were given 10 days to come into compliance with the list of violations. Search of the Clerk of Court on October 26 found a writ of possession issued. Site inspection found the residence is now vacant, outside storage removed, the jumper cables removed from the riser, but all other conditions remained unchanged. That concludes my testimony.
Thank you. Just want to take a look at the photographs for a second. Yes, sir.
We had sold the property on a land contract, and we had to foreclose, as she had stated. We couldn't get possession of the property until the first week of October. The day we got possession, the next day we hauled 24 cubic yards of the debris and waste, and it was unbelievable how these people were living. We cleaned the entire house out, tore down all the partitions they'd put in the garage, and capped all the wiring, everything we could do. The windows, the doors still have to be done. When they hooked up the jumper cables to the electrical pole, they have fried the whatever system goes between FP&L's meter box and the top of the house. And we are on a work order with FP&L now for them to come out and tell us they have to do it because it's the line coming in from the house. And we're on their work order, but they said they're way backlogged because they'd been shipping everybody to the East Coast after Matthew. And a lot of their people are now on vacation and so forth because they were working so many days straight. So we call every 3 or 4 days. They tell us they'll give us a call back. The work order's there, and we're just waiting for the power. We have a contractor ready to start the work, but he says he's not even going to put us on the line until we have power and he can see we're ready to go.
Okay.
So the power is the only thing that's holding us up. We want it done. It's costing us money sitting there every day, sitting empty. We want it back on the market.
Okay. Anything further, sir?
I don't believe so.
Anything further from the county?
Officer Leonard, is there anything further you'd like to add?
No, Mr. Birch has made efforts. He's been in touch with me multiple times. It is vacant, to my knowledge. It needs to be secured. If it's going to be a while before he can get a contractor in, they need to get the house secured. The rear door was open the other day. Looks like possibly from the sheriff's office when they had to go in. And the windows are broken, but he has cleaned up all the junk. The grass is being maintained. It's just an issue of getting the repairs done to the property.
Well, it sounds like you made a reasonable effort, and I'm concerned that the FP&L, can't get to you to finish everything. Do you have any idea how long it would take to get FPL's response?
Our original, and this was the day before Matthew hit, was they said it's 7 to 10 business days. Mm-hmm. And then we understood, we didn't even try to call back the next week because we knew their FP&L crews were busy. 2 or 3 weeks later, we called back. They said the work order's there. We're obviously running behind schedule. We called back a week later. We just keep going over every week hoping our meter's there. And maybe they didn't call us or something. So, we're trying everything we can do. We're paying taxes, insurance, water bills, everything we can while the house is just sitting there empty.
Mm. Any idea how long it would take, you think, to get this property cleaned
Once
up?
we have power, less than a week. The contractor said all I got to do is it's standard size windows, take everything out, put new windows in, put new front door in. That's the electrical panel. Luckily, that fried above it, so it didn't actually hit the electrical panel. It fried between the FP&L's box and the mast on the roof. So electrical-wise, everything seemed to be fine from what we could tell without it being on.
Okay. Anything further from the county, if not its recommendation?
The county recommends respondent be found in violation of the code sections listed in the notice of violation as amended, and from the date of this order, 30 days to clear the zoning violations, apply for and obtain all necessary permits, pass all inspections, and bring the property into compliance with the International Property Maintenance Code, or thereafter face a fine of $100 per day for each day a violation exists, abatement in the event of noncompliance, and costs of abatement to be added to the fines and costs.
Do you follow all that?
Yes, sir. I do.
tell you what I'm going to do is I'm going to accept the county's recommendation, but I'm going to modify it. I'm going to give you 45 days, only because I think that might be sufficient to, get some response from FP&L and get this thing corrected. Is that acceptable?
Yes.
I think you need it. Okay. So what I'm going to do then is I'll find it when I see it. Okay. What I'm going to do in Charlotte County versus Jabe Inc., COD 161525, pertaining to the property located at 3373 Edge Hill Terrace, Port Charlotte, Florida. I'm going to find that the undisputed evidence establishes the existence of the charges set forth in the notice violation. I'm going to accept the county's recommendation, except I'm going to give you 45 days. I will ask you if you run into a problem, contact somebody, okay?
Yes, sir. Is it Rondai contact?
Yes.
Or?
Yeah, that'd be fine, okay? Because, I mean, really, if you get it done, there's no fine or
Yeah, that's what we're hoping to do. Like I said, it costs us money every day. It sits empty.
You want
Just go ahead and sign it.
Okay. All right, then we'll send you a copy of this order as modified, and good luck with that, okay?
Thank you, sir.
You're welcome.
This sign too. The dismissal of
Yeah.
Got that done. And I'll just make sure. G. As in green.
We'll take us to agenda item G, COD 16820, estate of Gail Noel. If you're present on that, please approach. Your name, sir?
Anthony Noel.
We'll go ahead and have the county go first, and then we'll allow a response. If the county's ready to proceed, it's first witness, please.
Officer Nicolosi.
Darcy Nicolosi, Certified Code Compliance Officer for Charlotte County. The property in violation is 2950 Bourbon Street. It's zoned MHC. The owner record is the estate of Gail D. Noel. On March 14th, I conducted an inspection of the address and heard the generator running. The property was posted no trespassing. A letter was sent to the owner giving 10 days to comply. At the re-inspection on March 30th, I was able to do a full inspection of the property with the tenant, and I observed the following violations. Power to the residence came from a generator running in the shed, an RV bus being used for living purposes hooked up to septic system, outside storage of batteries, canoe, door, and assorted other debris. The property was posted unsafe for no electric power to the residence. During the investigation, I took photographs of the property on March 30th, June 7th, September 29th, and October 26th. These photos fairly and accurately represent the condition I observed. I would like to offer the photographs into evidence as County Composite Exhibit 1.
Commissioner Noel, do you have any objection to me admitting those photographs?
No, I don't.
Okay, then those will be marked as Charlotte County Composite Exhibit 1, admitted into evidence. Please proceed.
The notice of violation was served in accordance with Florida Statute 162. The respondent was given 10 days to come into compliance, reference the existing violations. This case has been continued twice to allow the owner to contact the tenant and hire an electrician to correct the electrical violation. On September 29th, I conducted a final inspection, finding the generator still in use, outside storage remained on site, and the RV still being used for living purposes, as evidenced in the photographs. A review of the database found a permit had not been submitted for the electrical violation. On October 1st, Anthony Noel requested a 30-day continuance from the magistrate to allow more time to hire an electrician and have the power turned on, and clear up the other violations on site. The continuance was granted. On October 26th, I conducted the final inspection, finding all violations remained on site as evidenced in the photographs, and a review of the database found an electrical permit had not been submitted. This concludes my testimony.
Anything further from the county at this time?
Nothing further.
Mr. Noel?
As of, and up until yesterday when I had contacted Darcy, I was under the impression by the electrical contractor that I had hired, I've already paid him to do the work. He's already done the work. He, as of right now, this morning, still claims that there is a permit been pulled for that electrical work. He has, I have one more installment of payment to make to him, but other than having the FPL come out and hook up the electricity, the work is done for as far as that is concerned. The boat is gone. The tarp, I don't ever remember seeing the tarp there that I've been there. I was in there a couple days ago, and the place is cleaned up. I'm not exactly sure where the miscommunication between the electrical contractor and me occurred, but even as of this morning at 7:30, he says that there's a permit pulled. But my wife has been trying to contact him repeatedly while I've been here to get that number for that permit, and now I'm not able to get any contact out of him at all.
Who's the electrical contractor you're
Bright Future Electric.
We know if there's a permit that has been pulled?
Officer Nicolosi, when did you check the database and find no permit application?
This morning. I checked before we came to the meeting.
And no permit?
No.
Do you know if your electrical contractor's licensed?
Bright Future Electric, I believe they are. I mean, they're a multi-million-dollar company. I would say that they're licensed.
But the house is still powered with the generator?
The generator has been disconnected. The house wasn't being powered by the generator, the bus that was sitting next door, because the gentleman that wanted to move into the house, he's been staying in the bus until I can get this resolved. And that's where the issue with the generator is. It wasn't running the house itself, it was running his bus. It was allowing him electricity to run his bus. And I spoke to him a few days ago and told him that needed to stop, and he disconnected it. And he has started to transition and move his things into the house, because I was under the impression up until yesterday that there was an electrical permit pulled, and the gentleman has already been in and done all the work. The panel's been redone, the water heater has been hooked up, and those were the issues that caused the electricity to be disconnected in the first place. The previous tenants had replaced the water heater, but they didn't pull the permit. When they didn't contact me about any of this beforehand. They had put the water heater out to the road. The compliance officer drove by, I guess, and saw it, wanted to see it, found out there was no permit for the water heater, then wanted to see the work. Once he saw the work, he said this is not in compliance, and called FPL and told them to come out and disconnect the power. And from that point, then it's just basically steamrolled on me here, and I've gone through two different electrical contractors. The one fell through, and the other one here, Bright Future Electric, they're still telling me as of early this morning that there is a permit pulled. He's already been in, done the work, and I'm just waiting for him to get the inspection, as far as I know. But now apparently there is no permit, and I'm not exactly sure where to go from here with that, other than I just need to get that permit and get the inspection done.
How much have you paid the contractor?
$328, $29, and he's still is requesting another 200 and some. I have the specifics at home. I didn't bring it this morning. I wasn't thinking.
And what relationship to, I'm sorry, are you the personal representative of the...
Yeah, it was my grandfather. He passed away 6 years ago, and I inherited all this.
Okay, I understand. Okay. Anything further from the county?
Officer Nicolosi. Officer Nicolosi, how recently did you observe the residence being supplied by a generator?
Let's see. The September 29th, I heard the generator running, and October 26th.
That was not supplying the residents. That was supplying the bus.
I can't tell, which way.
I understand.
Yeah. Mm-hmm.
And how recently did you observe the outside storage of the batteries, canoe, and doors?
That was on the final. There's still things laying around, which is evidenced by the pictures, by the photographs.
Nothing further.
Anything further from you, Mr. Noel?
I don't believe so, unless there's anything more that you need. You see all that stuff on the side there. That shouldn't be there anymore. That wasn't there the other day when I was there. That bus there is what the generator. He had the generator hooked up to. That bus right there. That bus is his storage for all of his things that he'll be moving into the house as soon as I can get this resolved. I'm not exactly sure why there's a miscommunication here about this permit. I mean, I just don't get what the problem is. He's told me that the permit was pulled the last month, the day I was here last month. He said we pulled the permit that day.
Okay. County's recommendation, please.
The county recommends respondent be found in violation of the code sections listed in the notice of violation, and from the date of this order, a 2-year cease and desist order for any future zoning violations, 15 days to cease using the RV for living purposes, restore approved power to the residents prior to occupancy, and clear the zoning violations, and 30 days to apply for and obtain all necessary permits, pass all inspections, and bring the property into compliance with the International Property Maintenance Code, or thereafter face a fine of $100 per day for each day a violation exists, abatement in the event of noncompliance, and costs of abatement to be added to the fines and costs.
Thank you. Question for the county. What's the ballpark on if this electrician doesn't have the permit to get one? Are we talking about a week or less? Or
The permit processing time?
Yeah.
Right now, real quick, it should be.
I couldn't tell you positively, but depending on what's actually being done and how long the reviews would take. If it's real simple, maybe a week, but I can't be positive.
Okay. All right. In Charlotte County versus the State of Gail D. Doel, COD 16820, relating to parcel number 412017257002. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation. I'm going to accept the county recommendation as my order in this matter, but I will tell you, sir, that you've got to get that permit resolved, because the rest of this,
I realize
and if you comply and get all this done, then you won't be paying any fines or anything. You understand that?
I do, yes.
Okay, but that living in that bus makes me a little nervous, with that power. Okay, thank you, sir.
Thank you.
Jay.
Agenda item J, case 16-1349, Howard Goodrow. If you're present, please approach the podium. Gentlemen, your names, please.
Howard Goodrow.
Michael Goodrow, my son.
Morning, gentlemen. We'll go forward with the county, and then we'll come back and you can present your case. So if the county's ready to proceed, your first witness.
Officer Brown.
Stephen Brown, Certified Code Enforcement Officer for Charlotte County. 17476 Quincy Avenue is zoned RSF 3.5. The owner of record is Howard D. Goodrow. May 2nd, 2016, Lyndon Reinwald conducted a site inspection finding outside storage, creating junk-like conditions, and a prohibited use of the property. July 15th, I conducted a site inspection finding that a lot of progress had been made since Lyndon's inspection, but the outside storage and junk-like conditions still existed. I extended it 20 days. I took photographs. August 5th, 2016, a site inspection seen a little progress. Some items were by the road for garbage pickup. They're still working on it. Photos were taken. October 19, 2016, site inspection finding more progress, but the violations of wood debris on the front side of the house, metal cages, and junk in the backyard. I posted the property for hearing. Photographs. November 1st, 2016, site inspection violations still remain. Photos. I took photographs of the property on July 15, 2016, August 5th, 2016, August 19, 2016, November 1st, 2016. These photos fairly and accurately represent the conditions I observed. I'd like to offer the photographs into evidence as County Composite Exhibit 1.
Gentlemen, do you have any objection to those photos being admitted into evidence? Okay, thank you. Those photos will be marked as Charlotte County Composite Exhibit 1 admitted into evidence. Please proceed, Officer Brown.
I have not had contact with the owner, but I have had contact with the owner's son, explaining the violations and what needed to be done to bring the property into compliance. Notice of violation was served in accordance with Florida Statute 162. This concludes my testimony.
Anything further from the county?
Nothing further.
Gentlemen.
Everything's accurate. It was just time-wise. It was my doing. There was a few problems with the house a couple of years ago. We had to do a lot of work, extensive work. I'm just asking for an extension. I've got most of it cleaned up already. All the cages are gone. All the awnings that they were visible, those are gone. I do have a pit back there that's a burn pit. I burn. I'm gonna, as soon as that gets done, I'm gonna have somebody come out with a little skid steer and clean it out for me, and probably either fill it in or whatever. On the side of the house, I am building a tree house for my kid, my daughter, and that's I had a couple of sawhorses back in the back, and they had a bunch of wood on it. I've moved those over to the side, so if the side of the house is an issue still, I can take all the wood and stuff like that, and I can store it inside my shed. I'm willing to do whatever we have to do to get this rectified today. So.
How long do you think it'll take you to do?
I don't know, maybe 30 days. Probably won't even take that, but I would ask for 30 days if that's fine.
Let's see what the county says. What is your county's recommendation, please?
The county recommends respondent be found in violation of the code sections listed in the notice of violation, and from the date of this order, a 2-year cease and desist order for any future zoning violations, and 30 days to clear the zoning violations, or thereafter face a fine of $50 per day for each day a violation exists, abatement in the event of noncompliance, and costs of abatement to be added to the fines and costs.
So really, as of November 1st, it looks like we just have some items in the backyard here that need to be cleaned up.
Yeah, he's done a great job. It's just been very slow. for several reasons, but overall he's doing good. It's just the case was just taking a little bit too long, and we needed to move forward.
Okay, I understand.
I'd like to add something, if I might.
Yes, sir.
I was unaware that of all these periods of times when pictures was taken and the visits. I knew there was some time ago, 2 years ago or a year ago when it started, but I didn't know of all these site visits that they had. If I had known about them, I probably might have expedited this whole thing.
No, I understand. I mean, it's obvious you guys have taken this seriously, and you have a little bit more to go here. I want to make sure you have enough time to do it, before any fine kicks in. All right. Well, the county's recommending that we give you 15 days to clear the zoning violations.
Your Honor, we recommended 30 days.
Okay. Well, that'll give you the 30 days that you need, and with that, then I'll go ahead and announce my ruling on that, but we'll do it official, okay? All right. Charlotte County versus Howard D. Goodrow, COD 161349, parcel ID 40212442920. Find that the evidence establishes the existence of the charges set forth in the violation. I'm going to accept the county recommendation is modified, so you'll have 30 days. And if you're making an effort and you run into a jam, call somebody, okay? Thank you, gentlemen. Takes us to agenda item P, KCOD 16799, Edwin Pickrell. If you're present, please approach. I note that the county has a motion to dismiss the violation charged in section 3-9-79.1.
Yes, Your Honor.
Okay, that will be dismissed.
Thank you.
Your name, sir?
Edwin Pickrell.
All right, sir, we're going to proceed with the county going first, and then we'll hear your response, okay?
Yes, sir.
Officer Moore.
Renell Moore, Certified Code Enforcement Officer for Charlotte County. 6120 Taylor Road is zoned MHC, Mobile Home Conventional. The owner of record is Edwin G. Pickrell. This case was initiated by myself July 26, 2016, when I conducted an inspection of the address and observed the following violations. Outside storage, but not limited to tarps, wood, plastic, satellite dish, and assorted other debris on the property, creating a junk-like condition and prohibited use of the property. And a motorhome being stored on the vacant, unimproved property prior to the construction of the principal use. A verbal warning was given to the owner by outlining the violations, allowing 30 days for compliance. During the investigation, I took photographs of the property on July 26th and October 19th. These photos fairly and accurately represent the conditions I observed. I would like to offer the photographs into evidence as Charlotte County Composite Exhibit 1.
Yeah, that's pretty much it.
Mr. Pickrell, do you have any objection to me admitting those into evidence?
No, sir.
Okay, then those will be marked as Charlotte County Composite Exhibit 1 and admitted into evidence. Please proceed, Officer Moore.
The notice of violation was served in accordance with Florida Statute 162. I have had contact with the owner and some progress has been made. On October 19th, 2016, I conducted the final inspection, finding that the motorhome has been removed, but the junk-like conditions still exist. This concludes my testimony.
Anything further from the county at this time?
Just like to note that the motorhome is the code section that has been dismissed.
Okay, that's fine. Mr. Pickrell?
Yeah, the motorhome's gone, of course.
Yes, sir.
And all that, the hood and stuff I put there because I'm waiting on a permit from the county to put my motorhome, my manufactured home on the property, but it hadn't been released yet. They wanted a survey. We went and got the survey. Then they wanted a engineering of the survey, and then we got that done. And then they wanted an engineering of the survey. So, yeah, well, I'm just waiting for the permit to come out so I can put my modular home on there. But I've cleared all that up.
What we're looking at there
Wood.
is gone? Is that what you're saying?
Sir?
Can you?
Yeah, the hoods and all is all gone, except I have some building material there.
Okay.
The last picture pretty much showed it.
I'm
She
sorry, the
went
last
out there
picture,
and- There's another picture. No, it's not showing up. I saw that. No. There's another picture. This is the last picture she took where I get cleaned up.
All right.
I still don't see it.
Anything further, Mr. Pickle?
Excuse me?
Anything further?
No.
Anything further from the
I just wanted
county?
to show you that it was
I'm sorry?
up. I'm trying to comply.
Yes, sir.
Cleaning everything up.
Yes, sir.
What's the recommendation?
Please.
The county recommends respondent be found in violation of the code sections listed in the notice of violation as amended, and from the date of this order, a 2-year cease and desist order for any future zoning violations, and 15 days to clear the zoning violations, or thereafter face a fine of $50 per day for each day a violation exists, abatement in the event of noncompliance, and costs of abatement to be added to the fines and costs.
Mr. Pickle, can you get this cleaned up?
No, I just want to make sure I get the permit out so I can get my home on there.
Yeah.
With the permit, if I get it from the building department, 30 days I think I'd have everything done with my home on the property.
Okay. Yeah. Well, in light of the fact that you're making an effort to do this,
Yeah, I am definitely.
I will. I think I'll give you that 30 days, but it's going. You're going to have to exercise good faith and make sure that you follow through on that. So, in Charlotte County versus Edwin G. Pickerel, case COD 16799, parcel ID 412327151006. I find that the evidence establishes the existence of the remainder of the charges set forth in the notice of violation. I'll accept the county recommendation as modified, giving you the 30 days that you need. Hopefully everything will be done by then, okay?
I hope so.
Oh, thank you, sir.
Thank you.
Yes.
Okay, thank you. We'll move to agenda item S, COD 1625553, Bruce Thompson. If you're here, please approach. You're Mr. Thompson?
Yes.
Good morning, sir. Okay, we'll go with the county first, and then you'll be afforded a response. So if you have any documents you need me to see, just have those ready if you would. Not just yet, but just have them ready, okay? All right, county, ready to proceed. It's first witness.
Officer Moore?
Rennell Moore, Certified Code Enforcement Officer for Charlotte County. 27418 Los Lomas Drive is zoned RSF 3.5, residential, single family. The owner of record is Bruce Thompson. This case was initiated by myself August 16, 2016, when I conducted an inspection of the address and observed the following violations: structures being constructed without permits, clearing the land without permits, an unsafe structure, and miscellaneous items creating junk-like conditions and prohibited use of the property. A verbal warning was given to the owner by Officer Drown, outlining the violations and allowing 30 days for compliance. Officer Drown also placed a stop work order at the time. He is present today to testify. An unsafe structure notice was posted on October 6, 2016 by myself, and the owner removed it as of October 7, 2016 when I performed an assessment and well-being check after Hurricane Matthew passed. During the investigation, I took photographs of the property on August 16, 2016, September 16, 2016, October 6, 2016, and October 26, 2016. These photos fairly and accurately represent the conditions I observed. I'd like to offer the photographs into evidence as County Composite Exhibit 1.
Mr. Thompson, do you have any objection to me admitting those into evidence?
No.
Okay, thank you. And those photographs will be marked as Charlotte County Composite Exhibit 1 and admitted into evidence. Please proceed.
The notice of violation was served in accordance with Florida Statute 162. I had brief contact with the owner on October 7th, 2016. He advised that he was going to continue to build and bring pictures of his own to the hearing. On October 26, 2016, I conducted the final inspection, finding that the violations still exist. This concludes my testimony.
Anything further from the county at this time?
The county calls Officer Drown.
Please proceed.
Officer John Drown, Charlotte County Licensing Division. On 8/16/16, I responded to a complaint for possible unlicensed contracting at 27418 Las Lomas. On arrival, I observed Mr. Thompson working on a structure. I asked who he was. He stated that he was the homeowner. Review of the Charlotte County database confirmed this information. Further review of records showed no permit listed for the address. I took photos and posted a stop work order. At that time, Mr. Thompson requested that I leave the property. I then explained he was required to obtain a permit within 30 days and to stop all work. I then placed a call to Code Officer Moore in code compliance. This concludes my testimony.
Thank you. Anything further?
Nothing further.
Mr. Thompson, what's going on?
Actually, when I first started, I received I was a school teacher in St. Lucie County. I noticed y'all had some property here, and I bidded on it. I won the property. So when I also won I also applied and got a project loan through Home Depot. And through Home Depot, they have contractors with Tough Shed, and then what they do, they build. I was looking to build a tiny house, and I had paid them to build it, and they was pulling the permits and everything. So when they went to pull a permit, they said here in y'all county, they got denied because y'all not into the fad and new thing with tiny houses for people who's trying to be economic. So then the person who was the contractor who was pulling it said that y'all said I need to build my own structure, have a structure on the property, and then if I want to apply for a tiny house, which y'all consider a barn, and even if they would put the ventilation and all the things to make it a tiny house, y'all wouldn't consider it or whatever. So then I started to build my structure, and then when he came, Mr. Brown or Drown came, he gave me his card, and he looked at it, he said, well, you do have the building erect already, but he said I couldn't have any contractors help me with it. But at that point, I was indigent because I had left over there where I had work, where I could have worked, and came here and started building a house and working every day on my own on this house. So I was not employed. Since then, I have became indigent because I've been working on the house to get it how y'all want it.
That's right.
My food stamps and everything else. I couldn't get a contractor to do anything because initially where I had my plan to have the contractor do it and I paid them to do it, it was declined by Charlotte County. So then he told me that I couldn't have any contractors anyway help me with the house because I didn't have the permits pulled. But since it's erect, I need to finish it and then come with some plans and get, I guess, an after-build permit or whatever plans I have. Because he asked me if I had any plans or I was like, I'm doing it myself. I go to the Home Depot. The people in the Home Depot tell me, all right, this is the best product to use. Get these type of hurricane-proof windows and things like that. And I was doing it all myself. So he would come by periodically to make sure I'm the only one out there working on this structure that y'all see now in front of y'all. And because he said it's $1,000 violation if contractors help me and I don't have the permit and stuff. So and then if I got friends to help me, I couldn't pay them like over $200 or else it'll be a violation and I get charged $1,000 or something like that. And then after that, he came by. He drove by a couple of times to make sure that I was the only one. Then after a while, I seen another truck come by, but nobody stopped and talked to me. I seen a woman in the truck take some pictures and kept going. And then the hurricane came. I had the structure up at that time, and I was staying in the structure at that time. And I guess it might have been her. I was there, and I was trying to get the yard together, and I seen her stop, and her and another lady inside the truck. So I walked up to them, introduced myself, and they was like, well, we just making sure that you made it through the hurricane, da-da-da-da. And that was it. And then they pulled off and left. Then actually, I didn't get any letter at my house. My mother called me and told me that a letter was sent to her house. So when I went, that's how I got the notification. So I wouldn't have even known I had court today. It says that one was served to my house. I didn't get anything there. But I did get a letter. My mother told me that y'all sent. There's 2 places served on the letter, and she got the one at her house. So I went and got it. I have since then. I looked at the paper, what they had said. I did all the things that I'm indigent, so I couldn't file for a permit at that time. But since then, I've received employment in Lee County as a substitute teacher. I recently applied here in Charlotte County as a substitute teacher, but they don't accept the downloaded transcripts. They needed my master's in information technology in order to move forward with my application. And since then, I also interviewed at Port Charlotte Middle School for a technology position. So hopefully after a while, I'll be able to save up enough money, and I could actually get contractors that could come out and do the permit to do the knockdown, because he was saying I was going to need a knockdown on it, like the stucco. So I went to Home Depot, rented the stucco thing, sat out there and stuccoed as best I can, but they don't have the industrial strength one. So that's how it came out like that. But it is all sealed up. I have ventilation. I brought pictures. I went with solar energy. I have solar panels. I have solar energy. I have solar lighting. I have solar ventilation within the dwelling. I have current pictures.
If you want me to see those, if you would show them to the county attorney first, and then. But you can talk to me while she's looking at them.
All right, and then also there was an issue with my truck. I have a truck. When they came, it is registered. If they looked at the tag, they would see everything was up to date and everything. The truck actually broke down when I was hauling my car up here on the U-Haul, and it took U-Haul a month to I guess send me the money for the insurance claim, because I took out the insurance on it, and the guy who attached the U-Haul did it incorrectly. And it like froze the steering column and broke the shifter cable. So I changed the steering column, and then when I changed the steering column, I noticed that the shifter cable was too tight. I went online and I found out that there was recalls on the vehicle. So I took it up here to Palm Chevy, and that's a whole nother ordeal that went through there. I don't know, I guess it's bad luck or whatever, but it's a whole nother thing that went on up there. But I do have my insurance to show that the vehicle, the truck that's in the picture, and it's not a junk looking truck. Really, I'll give that to you.
We have no objection to the pictures, but would like to note that if the structure is being supplied by a generator, that would not be allowed either.
I have solar panels on there.
Okay, he's going to bring those photographs up to me, so I can see these. Now, do you want to admit these into evidence, because they're going to go into evidence? I may not be able to get back to you.
Yes, sir.
Okay, let me just take a look at. I'll go ahead and mark these as composite exhibit A for the respondent.
And I have my billing statement from Home Depot, but when they sent it, it doesn't have the specific items that was bought to show that everything is not is new, and all the materials on the structure is not. As I was looking at, and the thing is, I guess I forget the verbiage that was used, but like old materials. I have a smoke detector. I also have the fire alarm. I have the battery bank, and I have the inverters to go for homes, and it's also tied into a solar grid.
Okay, I understand. Is that your only copy of that?
I could go online and pull it up.
Okay, do you want to show it to?
You need an itemized one that shows the receipts of all of the products. I can request one, but that is what they sent me. Even up to the hangers that's used to hold the ceiling, they have me with hurricane-proof ones. I mean, everything is up to, all the materials is up to code that they have. The windows, they gave me windows that's, I guess, hurricane-proof. And the structure did quite well because, as she said, she rolled by, and I was in there for the hurricane.
Yeah, you can bring that up. Thank you, sir. We'll go ahead and mark, any objection?
No objection.
We'll mark this respondent composite B.
If you need my insurance, that's showing that the vehicle is insured and up to date with the insurance and tag and registration. I'm still in the process of trying to get the trans shifter cable, but I did move the vehicle into the carport area that I put, because I noticed it said that you can have one vehicle as long as it looks in decent condition and the vehicle is in decent condition. It would be running, but I mean, I don't know what the people at this Palm Chevy, they wouldn't give me any paperwork that they had the vehicle in there or anything. I mean, it was ridiculous. I couldn't believe it.
I understand.
Your Honor, the vehicle's not part of the case at this time.
Anything further, Mr. Thompson?
No, sir.
Okay. Anything further from the county at this time?
Officer Drown, is there anything further you'd like to add?
Not at this time. My conversation with him was simply that he needed to hire a contractor to be wary of unlicensed contractors. So they were required to be licensed to assist him. My recommendation to him was to hire a contractor.
Thank you. Officer Moore, what date did you check the permitting database?
I checked it yesterday, and there was no permits.
No permit applications for anything for this property address since the date you received a complaint? Or
Not that I could find, no.
nothing further?
Thank you.
Do you want to say something? The county calls Ben Bailey, building official.
For the record, Ben Bailey, building official, Charlotte County. After hearing some of the testimony here and seeing some of these pictures, he might have some code compliant components with maybe windows, smoke detector, but the overall design of this project is certainly not code compliant. And I doubt that there's going to be any engineer that's going to sign off on the design of this. And if he doesn't take it down, the county will end up taking it down, because there's no way this would pass code as it's designed.
Thank you, sir. Any response, Mr. Thompson?
Yes. Who is that?
He's the building official.
The who?
He's in charge of the building department in the county.
Okay.
Yeah.
He's here for this case?
I'm sorry?
Here for this case? He's here for this case?
I understand what
He's here specifically for?
He's asking if he was here for this case. He's here for any response necessary during the hearing.
Yeah, they have. This is not like a courtroom in the sense that we have strict rules.
Oh yeah, because I mean,
but he's, he is the building official. He's in charge of all of this that goes on with buildings, so he's permitted to testify. I know you don't necessarily agree with what he has to say, but he's.
No, it's not that. It's just like I mean, different places I get like different type of treatment, but it's always in a bad manner. I guess people, in order to show that they're in a specific role, they have to do something in a bad manner. That's the same thing I received that Palm thing. When I walked in there, I came in and brought my truck. The guy said, "You need to speak to the manager." I was like, "No, I'm bringing my truck as a regular thing like I think." And I ended up having to speak to the manager. And I told him himself, I mean, I have to speak to people of higher authority in a bad light.
All right, what is county's recommendation on this?
The county recommends respondent be found in violation of the code sections listed in the notice of violation, and from the date of this order, a 2-year cease and desist order for any future zoning violations, 15 days to clear the zoning violations, and apply for and obtain all necessary permits, then pass all inspections in accordance with the Florida Building Code, and bring the property into compliance with the International Property Maintenance Code, or obtain a demolition permit and restore the property to its original condition, or thereafter face a fine of $50 per day for each day a violation exists, abatement in the event of noncompliance, and costs of abatement to be added to the fines and costs.
Thank you. Mr. Thompson, you're going to need to get a permit pulled through a general contractor and have the plans properly submitted. My concern is that the evidence strongly indicates that you've not complied with the applicable rules and regulations relating to that. And I don't mean to add to a difficult financial situation you're already in, but I'm very concerned that that might fall in on you and hurt you or someone else. So here's what I'm going to do. In Charlotte County versus Bruce Thompson, COD 162553, pertaining to parcel ID 422310481013, I find that the undisputed evidence establishes the existence of these charges set forth in the notice of violation, and I'm going to unfortunately have to accept the county recommendation as my order in this case. So it's not going to give you a whole lot of time, to get a general contractor, but I would certainly urge you to do so because the county is indicating that it may apply to demolish the improvements.
But my thing is, if she came by and it was still a hurricane, what else is the issue?
Well, I'll let you speak to the folks out in the hallway and explain it further, but there's a lot of issues. We'd be here most of the day going through them.
Yeah, I mean, you're right. There is a lot of issues, and it's a shame that it's like that.
No, I understand that, but we all have to play by the rules, though.
Not. That would be good if everybody did.
I understand. Okay. Good luck, Mr. Thompson. Look at V. Victor.
We are, and we need to swear them in, I believe.
Do what?
We need to swear them in. Swear them in.
Oh, okay. They were late arrivals?
Yes.
Okay. Okay, that takes us to agenda item V, Marie Batiste and Jean Corville, case COD 16282. If you're here on that case, please approach. Good morning, folks. How you doing? Okay, why don't we start over here? If you just give us your name so we can get it for the record, please. Okay, sir?
Wanda Baptiste, husband of Marie Baptiste.
Okay. All right, well, the county's going to go first, and so let's hear what they have to say, and then we'll give you an opportunity to respond. Oh, that's right. Wait a second. I think you all came in late. Did you all get sworn in?
I signed.
Well, let's be safe. Would you all raise your right hand if you're going to testify, and then...
Do you solemnly swear the do you solemnly swear the testimony you are about to give is the truth, the whole truth, and nothing but the truth? If so, please answer, I do.
Okay, thank you. Let's hear what the county has to say, okay?
Officer Rotahorse.
Good morning. My name is Gary Rotahorse, a certified code compliance officer for Charlotte County. Location of the violation is 2426 Beacon Drive, zoned RSF 3.5. The owners of record are Marie Baptiste and Jean Corville. On January 28, 2016, I conducted an inspection of the address and observed violations consisting of prohibited outside storage and multiple vehicles on the property that did not have current tags and an inoperable vehicle in the driveway. On March 29th, my inspection found several of the items had been stored or moved about the property. Vehicles had not been addressed at that point. I took pictures of the property on January 28th, February 29th, March 29th, May 3rd, May 19th, and June 2nd, August 8th, October 21st, and November 1st of all of 2016. These photos fairly and accurately reflect the conditions I observed. I will make a note that on the first slide, I had an error on the slide with the ownership information. I did pencil in or correct that on the side of the slide and initialed that, so it would be an accurate record. I'd like to offer the photographs into evidence as County Composite Exhibit Number 1.
Thank you.
Okay.
Do you have any objection to me admitting these photographs into evidence?
No.
Okay. Those will be noted and marked as Composite Exhibit 1 and admitted into evidence. If you proceed, officer.
The notice of violation was posted in accordance with Florida 162. The respondent was given 10 days to come into compliance reference the existing violations. I've discussed the violations in depth with the owners and husband and the daughter yesterday, and I've seen a lot of progress on it. However, a lot of progress has been moving things from the carport to the side and to the back. On my inspection yesterday, I noted that everything was nice and neatly packed. However, it was still in violation with regards to the outside storage. The vehicles have been brought in compliance. That concludes my testimony.
Okay. So we're talking about the other things other than the vehicles? Then?
That's correct.
Okay, I got you. Anything further from the county at this time?
Just like to note the notice of violation lists appliances, shelving, dollies, and assorted other debris. Nothing further.
Okay. Got it. Okay, who's first? Who wants to speak first?
Okay. All right. Yes, sir. Currently, right now, the property looks pretty nice, as the inspector mentioned. All vehicles are okay, except one vehicle that is permitted to stay on the slab. In terms of like items, I have about 3 or 4 plastic bins. I have stuff in there. I'm waiting on getting a shed to place these items and to make sure that everything is okay. Even though I feel that I've been targeted, it's harassment from somebody. I don't know who the person is, but it seems like come to a point where nothing but total cleanup will satisfy whoever is complaining about it. And it doesn't take too much to clean up the area that is left. A shed will take care of this. Closing the carport will take care of this. So what I'm thinking about is enough time to speak with some, I would say, contractors on how much it will take and how long will it be to close the carport. The carport has roof. It's an easy job to do. It's just a matter of getting the permit and the finance expenses to take care of it. It is more than sufficient to take care of what I have. It's only about 3 plastic bins, and nothing else. The shed will be sufficient too, but it's going to take getting some kind of like a finance deal to work it. So I don't, unless the gentleman has something else that he wants to do concerning my proposals, I don't know. The carport, sir. The carport, I was under the intention that it would be okay the way I have it, because it's just a portion of the carport. Let's say this is the carport for clearance. This portion is what I enclose. And it has baby toys. I have a dryer in this. But the rest of the carport is open, and it's pretty nice. I try to secure it, make it nice. But it seems that the person who's complaining is not going to be satisfied. And maybe I don't have the kind of money that person has to take care of everything. But I'm willing to work and to put this behind me. I don't want to be here. I don't want anything like this, because my wife is like very moved by this situation. So it's up to, I don't know, to the officers to let me know what to do now, and I'll see how much I can do into compliance.
All right, let's see what the county wants to do with this. The county have anything further, or if not, its recommendation?
The county recommends respondents be found in violation of the code sections listed in the notice of violation, and from the date of this order, a 2-year cease and desist order for any future zoning violations, and 15 days to clear the zoning violations, or thereafter face a fine of $50 per day for each day a violation exists. Abatement in the event of non-compliance, and costs of abatement to be added to the fines and costs.
Thank you. What I'm going to do is I'm going to accept the county's recommendation, but I'm going to give you 30 days, and it's probably about the best I can do with the, with the discretion that I have. I hope that you'll be able to get everything in order by then. It sounds like you're almost there anyway.
It's not a big thing.
All right, so Charlotte County versus Marie Batiste and Jean Corvell, KCOD 16282, parcel ID 402214477001. I find that the charges set forth in the notice of violation have been established, and I'll accept the county's recommendation as modified, giving 30 days for compliance. Okay?
Thank you, sir.
Good luck. I hope everything gets worked out for you.
Have a blessed day. Great day.
Have a good day.
Your Honor, I believe we have one more respondent present. Could we take a 5-minute break before we resume?
Yes, why don't we make it 10 minutes, and
thank you.
We'll stand in adjournment for 10 minutes, and then we'll convene. We're going to start with the KCOD 162945, Robert Dean Rose, after the break. Rose, trustees, if you're present on that case, please approach. Your name, sir?
Robert Dean Rose.
Good morning, sir.
Morning.
We'll proceed as the other cases, with the county going first, and then you'll be given all the opportunity in the world to respond, okay? County's ready to proceed. Its first witness, please.
Your Honor, this is the case in which I believe there are some neighbors present who wanted to speak for public comment. Would you like to address that now or later?
Is it connected to this?
As to this case, yes.
Okay, yeah, I preferred it that way, because that way it all melds together as opposed to having heard the statement earlier. But yeah, why don't we proceed, and we'll take the public comment at this time.
Okay.
So, ladies and gentlemen, if you regarding this this particular matter, I understand there's some public comment, and I think, sir, you wanted to say something earlier. So if you'd like to come up and address us, and Mr. Rose, if you just have a seat for a minute, and we'll hear the public comment. Again, your name, sir?
Yes. Good morning. My name is Cliff Cooley. I live at 117 Small Street. And for the last, 10 years, I was engaged as a volunteer in our community as the president of ELF Civic Association. That is about 300 homes that are just south of Edgewater, in an area that the property in question is located. And for a good part of that time, this property has been of concern to the people in the neighborhood. It is kind of outside the scope of most of the homes in the area. The way it was designed and constructed was to use every square inch of the property out to the setbacks, and it included in that was, a waiver of the setbacks to the seawall, which allowed them to move 3 or 4 feet further back. So the property is huge, and it has sat there. The activity on it takes place in annual events when Mr. Rose comes down. with his RV and his family and a crew of workers where there's frantic activity to build something or other, whether it's concrete or a wood structure on top, for about 10 days, and then they leave and it sits there. It sits there day after day, week after week, year after year, and the people in the neighborhood have to look at this. It is, we bear no ill will toward Mr. Rose, but he bears ill will toward us by leaving this thing uncompleted, because it's really a detriment to our community. So I just wanted to make it known that the community does not want this property to be there, or we want it to be completed, and so that would be, I guess, the extent of my comments today. Thank you.
Thank you, sir. Sorry you had to wait so long. Is there anyone else that wishes to make public comment? Your name, sir?
My name is John Walsh.
Where do you live?
I live at 260 Severn, next door to the property in question here.
Yes, sir. Please proceed.
My wife and I have lived at 260 Severn since 1998. We have lived with the situation at 274 Severn since 2007. In our neighborhood, the 274 property is called the Beirut House, and I think you probably know the reference to that. Mr. Rose has played the system of codes and permits since 2007 with little progress on completion. His property has been and is a blight on our area. The site has trash, old building materials, etc., and is unsafe for any curious children or sightseers. Windy days often bring debris from his property onto our property. We should not have to put up with these conditions and urge you to proceed with the demolition process. Thank you.
Thank you, sir. Anyone else wishing to make public comment, please approach.
Good morning, Board. Arthur Edward Preston, 157 Small Street.
Yes, sir. Please proceed.
Good morning, everyone. During the hurricane, many of us were not in compliance with the codes, and we appreciate the Board's diligence in trying to create a safe environment for us and to have the homes mirror what it should be in our community. So we appreciate that. Many of us were told that we were in violation and that we had to clean up. We had certain time frames, and we did that. What we're asking is for the same treatment. We're asking that if we have some violations in code, the spirit of the law is that we want safety and we want the community to look appropriate. So we would ask for your assistance in continuing to enforce the law as it should be. Thank you.
Thank you, sir. Anyone else for public comment? Okay, then we'll, Mr. Rose, if you would. Mr. Rose, I'm required to tell you that even though the public comment section was not favorable to your position, that my decision will be based on the evidence presented in your case. In other words, that's public comment. Now your case will be open and will be based on the evidence.
Thank you.
Okay. The county will go first, and then we'll proceed. So if the county is ready to proceed with its first witness.
Officer Davis.
James Davis, Certified Code Enforcement Officer for Charlotte County. The property in violation is 274 Severn Road and is zoned RSF 3.5. The owner of record is Robert Dean and Cindy T. Rose Trust. On September 19th, by referral of the building official, I conducted an inspection of the address, found a foundation on site with an unpermitted structure on top of that foundation. I also reviewed the Charlotte County permitting database, observed permit 2011-0201-555 for a single-family home, had expired without receiving final inspections, and has been allowed to remain in an expired condition for over 180 days. During the investigation, I took photographs of the property on September 19th. These photos fairly and accurately represent the conditions I observed. I would like to offer the photographs, a permit history, a timeline, and the building official letter into evidence as County Composite Exhibit Number 1.
Mr. Rose, do you have any objection to me admitting those into evidence?
No, sir.
Okay, then those will be marked as composite Exhibit 1 and admitted into evidence. Please proceed.
The notice of violation was served in accordance with Florida Statute 162. The respondent was given 10 days to come in compliance, referring to existing violations. On October 28th, I conducted the final inspection, finding the conditions remain the same. I do want to reiterate that the case before the special magistrate today is the fact that the permit is expired and has been expired for over 180 days. This concludes my testimony.
Thank you, sir. Anything further from the county?
Yes, the county calls Ben Bailey.
Please proceed.
You're Ben Bailey, building official, Charlotte County. I just wanted to summarize how we've got here. This was, like I said, the construction of a single-family home that this permit has been issued for 7 years. The community has been dealing with it for 10 years with the demolition of the original home. And the owners have been given every opportunity that we possibly can to help facilitate the completion of this home. There's been multiple permits, multiple extensions. The permits have expired 4 times. There was actually a period of time back in October of 2013 where we could have deemed it abandoned and did this process back then, but the previous building official didn't go that route. The last permit expired in March of 2016. He was sent a letter indicating they had till September 19th to come in with revised plans, and he has not done that. Every timeline that we've given him has not been met. The denial letter specifically indicated the time frame he was supposed to work in. The 180 days has passed, and therefore we are proceeding with demolition.
Thank you. Anything further from the county?
Yes, Mr. Bailey. Is it true that in April 2015 there was unauthorized construction that was not per approved plans on the property?
That is correct. The owners had come in with a revised set of plans, the original ones that were approved for a block structure. They came in with a small wooden structure that went through plan review and was denied for insufficiencies, and a comment letter was sent out to them indicating what we needed in order to have for that permit. Construction had actually started on that, and we had a stop work order.
And did it take several months before the county received an inspection report from an engineer for that wooden structure?
Yes, it was several months before we got an engineer's letter for that. It was not an approved structure. At the time, there was very few tie downs and was a threat to the community, so Mr. Rose had hired his engineer to go out to do an analysis. Apparently there were some straps put on to suffice until he came in with the whole set of plans, and that never happened.
And is it true that in March of 2016, the owners listed the property for sale in violation of the owner building permitting requirements under Chapter 489 of the Florida statutes?
That is correct.
And did that take place on March 12th, 2016?
We found a listing that was online. He was trying to sell the property, I think, as a last-ditch effort to try to get out from underneath this. He was told that under the contractor licensing laws, he's not able to market, sell, or lease a property that is under an owner-builder permit. So he really took the listing off. Shortly after is when he tried to get really a fourth extension on this whole project.
Was that 3 days later, on March 15th, 2016, that the owner requested a third extension on this permit?
That is correct. There had been a third extension on this permit. There was another extension on a subsequent foundation-only permit that was granted, which was back in February 10th, 2010. So technically, there's been 4 extensions on this project.
And the letter that was admitted into evidence that's dated March 22nd, 2016, that's a letter that you sent, Mr. Rose, correct?
That is correct.
And did that outline the fact that a plans change would be necessary, need to be submitted, and a passing inspection be conducted by September 19th, 2016, or the project would be considered abandoned?
That is correct.
And did it go on to explain that once a project is considered abandoned, the building official is authorized to require any work which has been commenced or completed be removed from the building site per Florida Building Code 105.4?
That is correct.
Thank you. Nothing further at this time.
Thank you. Sir, if you would just stand by in case we need to recall you. Mr. Rose, please proceed.
I will, to my best. If you could honor for me, if I don't address any issues that they've brought up that are of concern, could you please let me know so that I can try to address them?
Sure.
I'm going to try to be brief as I can on a very long and painful story for myself and our family. They have been working with us greatly, and I appreciate their efforts, and there's nobody who wants this home built more than us. We are both military, my wife and I. I'm recently retired. I did 21 years. I was special projects. I did black ops. I was a spy. I can tell you that now.
Thank you for your service.
I lost 4 friends on my last mission. It kind of put me on my heels. I had just had kids, had to count body parts. It wasn't good. I went through some PTSD stuff, counseling for a number of years. My sister came down, as I had mentioned before. My family came in and helped. Her daughter, oldest daughter, used to watch my kids on her way back to school after watching our kids while she was down here, T-boned, killed. Number of tragedies. My brother ended up getting colon cancer, misdiagnosed. I had to support their family because he was uninsured. Guy had 2 PhDs, but he lost his job because he couldn't wake up. They treated him for depression because he would work for General Motors, went out to California for a job. There were a number of extenuating circumstances. They're painful for me to rehash. I only bring them up to as why this has dragged on as long as it has. Initially as well, we had a home there that we had just got done remodeling, and we wanted to just fix that house after the hurricane, but because of the county's code that if the damage has exceeded 50% of the value of the house, you had to bring the whole house up to code. So we had to tear down our house that we had just got done remodeling, and we were underinsured to the new day prices. So we tore down the house, and it sat there. And then we were informed by our insurance company that we were going to lose 25% of our insurance claim if we did not start rebuilding in 2009. So it started in 2009 with a foundation-only permit. As well, we got notification that we were going to lose our homestead exemption. So we were forced to go ahead and start building. So we started building. We had money saved up, our lifetime investments. And General Motors my dad worked for General Motors, my brother worked for General Motors. We were heavily invested in General Motors. We lost it, almost everything. And we were unable to, we hobbled along trying to do our best to get this place done. We want our house there more than anything, and I mean anybody in this room. And we had to help my brother, my sister's brother on top of this was murdered in Atlanta. He came and lived with us. They caused a divorce between his wife and him. He brought all this stuff up to our house, and then he left. So I have all this stuff there. My dad has Alzheimer's, got arrested down here for trespassing, never had a problem in his life, thought he had a girlfriend in a hospital, got arrested, put him on probation. He was a federal firearms dealer. They asked him if he had any guns. He thought he meant on him. They violated him on probation, put a 75-year-old man in jail for a year. No way to get around it. I had to liquidate move all of his stuff out of his house. He had become a hoarder. When he was in jail, it became to my awareness that a 28-year-old girl had been looting him to the tune of over $200,000. And we built a case trying to get her and try to get this money back. And then he only recanted because she says that he's his true love or whatever. And he moved up there to me because he almost died after getting out of the jail. He had an infection. I had to move him all of his stuff. And his house was full of black mold, just destroyed inside. I had to gut his house, move all of him up to our place. I had to make accommodations for his guns, everything at our place, only to have him get up there and her to lure him back down here. I did not have guardianship over him. I had to go through the whole thing of trying to get guardianship. I had power of attorney. That was a whole, I chose not to do it just because the funds and the heartache and everything else I was dealing with. I didn't have the heart to do it. Now he's back down here. He just got robbed from her again. I'm still dealing with that. All that said, to say we have had a number of issues, and they have been very understanding regarding those issues, and I appreciate that. We were helping my brother's family after he passed. They recently moved back into her mother's house, and we are no longer having to do that. In addition, my wife was promoted, and now is the Deputy Inspector General for the Navy. And we have been trying, I've been working with Ben, telling him that, we've worked with a builder. We have a contract, we have money down, I have home plans, I have financing from the bank, and we would like to proceed and build our home that to be put there. We have state-approved plans already, and I just, I would like to put the past behind us. I apologize to my neighbors for the inconvenience of them looking at whatever it was. I mean, I have my yard mowed and everything else. I tried to keep it up as best we can. I mean, the columns they're going to be there when the house is done. I mean, it had to be raised 6.5 feet. We raised it 10 so we would have room underneath.
When did you retain a contractor, sir?
This was done in March. It was while I still had an active permit. And
why did the permit not get renewed? I mean, I know that you've had a lot of...
It bothers me too, sir, because I gave them authorization to do it, and I had to go to the CEO, they're a national builder, and the sales manager kept dinking around. He had some legitimate reasons. He fell and had surgery on his shoulder, whatever else. He didn't get the stuff submitted. They were supposed to have submitted. I have over 100 emails back and forth with me saying, you need to get this submitted. He went back, he made Ben promises of when he was going to have the stuff submitted and would miss them. And I'm like, dude, just get those plans to the state and get them certified. And I mean, I have emails here, sir, if you'd like to see them, of him telling me that everything was good. I've given him everything he needs. He just needs my okay to go ahead and submit the plans to the state. I gave him that on June 8th. And, we had worked out every little detail of the house. Everything was in the right place. No other changes have been made. And it took him 4 months. I now have the regional vice president of the company involved, and things have been getting done. And they're on track. I have the contract there. I have approval from the bank to build. I have the plans for the rest of it, tying the house into the structure that's there. I'm trying to do everything I can, and I have tried to do everything I can. So.
The plans you have, what are those dated?
The state plans for the house? Or?
Yeah, the latest set of plans. I'm just trying to figure out, if you've got a current set of plans to submit for permitting.
I have a current set. I just got these yesterday.
Okay. That answers my question then. Anything further, Ms. Burrows?
Have I addressed all of your concerns, sir? That's all. I just want to...
No, I understand what's going on. You're saying that you've had a lot of personal tragedy, but you've got everything in place, and you feel that you're in a position to get the permits and get this project underway. But and I just want to hear what the county's response is going to be. Okay. County have a response?
Mr. Bailey, isn't it true that on March 23rd, 2016, this permit expired for the third time?
That's correct.
And that it takes 180 days of no activity for the permit to expire?
That is correct.
and that there remained no activity for an additional 180 days until September 19th, 2016.
That is correct.
And under Section 105.4.1.2 of the Florida Building Code, if a new permit is not obtained within 180 days from the date the initial permit became null and void, the building official is authorized to require any work which has been commenced or completed be removed from the building site.
That is correct.
And how recently did you check the permitting records for this permit?
I checked them yesterday evening.
And was there any permit application by then? Do you have anything further you'd like to add?
Well, I'm very sympathetic to Mr. Rose. I have no ill will towards him, and I was hoping that this final deadline was going to be met. We have rules and regulations that we need to follow, and this has been going on for a long time, and I think it's unfair to those that have been through the system before that have had to go through this, and also unfair to the community to let this go on any further.
And is it your determination that this structure has been neglected or abandoned so as to become a potential harbor for vagrants or an attractive nuisance for children?
Absolutely.
Do you have any confidence that if the respondent submitted plans today, they would be approved and construction would proceed in accordance with the Florida Building Code?
Seeing the track record, I do not have that confidence.
Thank you.
Mr. Rose, did you have any questions of the building official?
No, I submitted plans, Your Honor, and they actually renewed my permit because the company missed his deadline, as he stated, and they were a week because the plans were at the state. They have to be state certified, and I submitted those plans afterwards, and I was granted the permit, and I paid the fee to get my permit renewed. It was then backed out, and I was told that they gave me a permit in error. I had been giving a permit, and I paid the fees to renew it, and I was ready to go. I started moving forward, and then I got a call that they were going to back out my permit and refund my money. I was trying to go forward. I'm ready to go forward.
Understand. All right, anything further, Mr. Rose, or from the county?
Yes, Mr. Bailey, could you elaborate on the error that surrounded the permit renewal?
The parcel itself in our computer system was on a lock, so no activity could be done on that without my authorization or the zoning manager. During that time, it would periodically become unlocked, so code enforcement could type in notes, and I guess during one of those times, it did not get locked. So at whatever time Mr. Rose renewed, it was not in a locked status, so our upfront customer service reps proceeded to renew the permit, not knowing that it was supposed to be locked. We did catch that error and refunded his money, which by Florida Building Code, I am allowed to revoke any type of permits that are done in error.
Understood.
And is it true that that took place only a couple of weeks ago? And that you have had direct contact with Mr. Rose and have made clear what the requirements and the deadlines were?
That is correct.
That September 19th, 2016 was the deadline to submit a plans change and receive a passing inspection, or the property would be deemed abandoned?
That is correct.
Thank you.
Your Honor, I don't know if that wasn't exactly clear to me. I see what you were referring to, because he had denied my extension request. I thought he was giving us time. I didn't realize the hard and date fast. I did see it in an email back and forth. I wanted it done before his deadline. I'm frustrated dealing with the sales manager. He shouldn't have been involved in all this stuff, and he blocked things down for 4 months and gave him dates that he didn't meet time and again. I seen the emails. He would say, hey, when are you going to get this? You said you were going to have it in here. And he wouldn't do it. I would send emails to him. I'm like, look, you need to get this submitted. He wouldn't get it submitted. I had to go all the way through their chain of command to get action. I had to go to their CEO, which finally got it done. I'm trying to get it done. Afterwards, I had my engineer submit new plans trying to get a new permit, and that was denied as well afterwards. We have a bank. We are ready to go. The only thing that the timeline to get this done, I have you see all those tie beams there and everything there. All they have to do, all that has to be done for a house to be there is there's a couple additional tie beams, or not tie beams, but columns for support need to be added because of the width of the house. That would take a day to build, and then the modular home company will start the construction to build the home, which would take about 2 to 3 months to finish. They will come in and set the house, and the house will be placed. After that, I have to do the deck up there on the top deck and some other finishing touches to it. I would hope to have it done within 6 months.
Let me ask the building official a question. Is this salvageable from his end if he brings in plans that ultimately get approved here?
The structure itself is salvageable. I mean, it is built well.
No, I mean the situation, is that salvageable? In other words, if he gets a proper permit renewed on this and has his proper authorized plans approved, and
that was the chance that he was given already. So back in October of last year, we sent him a comment letter indicating the deficiencies with his plan for that wooden structure up there, and it's been over a year now since there was no response.
We were in the process of changing that plans. That's why we didn't address those issues, because they were going to be changing, and it would have been a waste of your time and our time to address those issues, because we were changing those plans. Those circumstances had changed. My brother's wife had moved in with their family, freed up money that we could afford to do financing. We couldn't do financing for the longest time. Now as well, I mean, with my wife being promoted, we have financing secured so we can get this done.
What is the county's recommendation?
If I could have a moment.
Unless, of course, you have further.
I'd just like to note that under the Florida Building Code, it's the county's position that it's the building official's determination whether to allow new plans to be submitted and reviewed at this point in time, because the project has been deemed abandoned. And under the notice of violation, section 110.3 of the International Property Maintenance Code states that if the owner of a premises fails to comply with a demolition order within the time prescribed, the code official shall cause the structure to be demolished and removed. So the county is requesting that because the respondent has failed to obtain a demolition permit to restore the property to its original state within the 10-day period in the notice of violation, the county is recommending that respondents be found in violation of the code sections listed in the notice of violation, and from the date of this order, 10 days to apply for and obtain a demolition permit and restore the property to its original condition, including removal of the concrete foundation, or thereafter face a fine of $50 per day for each day a violation exists, for abatement in the event of noncompliance, and costs of abatement to be added to the fines and costs.
Your Honor, could I? Were you finished, ma'am?
Let me ask you a question. If we limit this to 10 days, will he have enough time if he wishes to appeal a decision, an adverse decision?
There would be no demolition taking place before the appeal time runs.
Okay.
Your Honor, the original demolition order was for the wood structure, the unlicensed. That was the only demolition order we've ever received, was for the wood structure. That was not. We had started the construction after we had put the plans in for review, so it was only for the wood structure. The foundation was completed, and I have a letter from the engineer stating that the structure is safe and that it meets all current codes.
All right. Mr. Rose, the county official has the discretion to seek the relief that they're asking for in this matter, and it's been 8 years since this house project started for you, roughly 8 years, and it's been 180 days, 6 months since the permit. It seems to me, as the trier of fact, that you've had every opportunity afforded to you to get it done. Now, I understand in your case that you've had some personal tragedies, and it's been god-awful, believe me. I understand that. But I don't hear any legal excuse why this has taken so long. And I think from the evidence that I've heard, and I'm not basing it on what the public comment was, I promised you I would base it on the evidence, but what I hear is that, at least what I'm concluding from it is that you've just sat on it for long. And I understand you disagree with me.
Well, no, I was just going to state, I mean, there was a stop work order put on it as soon as that, for debris in my place, and I couldn't do anything with the stop work order. They never relieved the stop work order. So I was in the process of making sure, getting everything together to do the plans. I mean, my kids have dug trenches. They ran the power lines. We have, my family has put their blood, sweat, and tears into this place. We were trying to finish our home. We didn't want to tear down the house that we had there. They made us tear down that house. That house would have been done. We would have had that house if we could have just redid it. And now I have a huge investment in this house already, both in my heart and in my financial pocket for this place.
I have no doubt, sir.
If I may, Mr. Bailey, could you elaborate on the foundation permit?
The foundation permit, not typical to a residential project. It was given in this instance to help Mr. Rose get things rolling. Because he has a foundation permit doesn't mean that it is legal. Once he had his permit for his house, that basically goes away, and then the permit for the house takes over. So to say that this foundation is legal is not correct. It would basically be considered an accessory structure with no primary. So there's no merit to, okay, I have a foundation that's approved, the county needs to let me have this. Once he has his building permit that was issued and approved for the house, that supersedes his foundation permit. It's like a Head Start type of permit.
Okay.
And is it correct that the county had to proceed with a case for an unsafe structure for the wooden property before the county received anything from an engineer certifying the structure was sound?
That is correct.
And that the notice of violation that is part of this case states that the respondent must clear the violations by obtaining a demolition permit to restore the property to its original state and pass final inspections. That's referring to the entire structure.
That is correct.
Thank you.
Your Honor, that was only the demolition order was only for the wooden structure. It specifically said just the wooden structure, and that's what I thought I was dealing with timeline. Worst case, that we would have to tear down the wooden structure. It was not about the concrete foundation. It was the wooden structure that was on there, and that was what, if we didn't have to, we would have to tear that down. That was going to be the worst case. There was nothing about the concrete structure until just now.
You know, we have actually two different issues. We've got the unpermitted wood structure, which was deemed as an unsafe building, going alongside of a possible abandoned project for the whole thing. So they were kind of running concurrently, and that's what the notice of denial said to him, is that this whole project will be deemed abandoned if you don't come in here by September 19th.
I requested an extension, and it was denied. He denied it.
It was denied because he did not bring any plans in like he was supposed to. And we had asked for plans back in October, and he had no indication of having any plans. He just gave us a hardship letter explaining pretty much what's happened over the last few years, which he's given to us before, and it was denied. and I didn't have any merit and any confidence to let that go through.
I gave him plans that had not been approved by the state yet, because that's all I could get from our builder, and I don't want to have another fight with them, but they dragged their feet, and I mean, for 4 months, and it just was, I have hundreds of emails, Your Honor, if you'd like to see it. I wish that they build a good home, but this guy that I dealt with there, he gave Ben dates, 3 times he gave you dates, and then he rambles on about things, and I'm like, it's not pertinent. You just need to submit your plans so that we can get this to the county. And I couldn't get it through his head. I had to go all the way up their chain. I couldn't get their regional vice president at first. He had issues with his son. And then I got a hold of the CEO. It came back down, and I got things done. But we were past the date that he had given us.
All right.
I'm trying to do everything, and I have done everything. And I know it's dragged on. And I don't think, I didn't start off this thing saying, hey, I want to drag on building a home for, 9 years or whatever else. I didn't want to destroy the house I had just got done remodeling. I put my heart into that place, built that place. We got deployed immediately after we finished remodeling it. It got destroyed by the hurricane. Then we had to fight with the insurance company back and forth with the county because they wanted to destroy it, and we had to end up destroying that house. Then I got 5 years after that date, the insurance company tells me I'm going to lose my other 25%, and then I get notification from the county I'm losing my homestead exemption if I don't start building. So I had to start building. Then, I think I got enough money to build if I do it myself, right? Then all my money goes away from General Motors. And now I've been doing the best I can to get this thing done. I know it isn't like anybody else, but there's nobody else in this room that wants that place done worse than me, worse than my wife.
All right, I'm ready to rule, so I'm going to, in Charlotte County versus Robert Dean Rose and Cindy T. Rose, trustees, case number COD 16-02945, relating to parcel 40222-635-3005. I find that the evidence establishes the existence of the charges set forth in the notice of violation. I'm going to accept the county recommendation as my order in this case. I know that you don't like that. You have the right to appeal, but I think you've been given a lot of opportunities to get this done, and for whatever reason, you've had some setbacks. No, sir. I mean, you
go over to Afghanistan 13 times, Your Honor. You get your friends blown apart in front of you, and then you deal with things. You get things done. You live over 1,000 miles away.
Sir, everybody in this room appreciates your service.
You can say that, sir, but your actions don't support that.
Well, if you're looking for your service career as a free pass,
it's not that. I've been doing everything I can, Your Honor, and I have met the codes trying to get parts done, getting people to respond down here as far as builders. We went through trying to get other builders. You can't get them to call you back. Then they call you back, they run you through, they waste your time. Okay, this was the good guys as far as getting them wasted time. That's why we were staying with them. Okay, we've been trying to get our house done.
Well, Mr. Rose, I disagreed with that, and I know you don't appreciate or like the result. You have a right to appeal this, and I put the notice of the time elements in my order. You'll get a copy of that. And perhaps you might want to retain legal counsel and appeal the decision, but I've made my ruling.
What is the appeal process?
It'll be explained to you in the order.
And we have to appeal based on what you're saying, because
if you believe that the evidence doesn't support my decision, is what you would appeal. Thank you, sir. All right, I believe that takes us to agenda item. Well, let's see, do we have anybody else left? Okay. We'll take us to agenda item A, COD 320, Levi Holding LLC. If you're in that case, please approach. I note that no one is present on behalf of the respondent. County's ready to proceed as first witness.
Officer DeShane.
Andre DeShane, Certified Code Enforcement Officer, Charlotte County. 3151 Cooper Street is zoned Industrial General. The owner of record is Levi Holding, LLC. On April 21st, 2016, I conducted an inspection of the address and observed the following violations of 2 handicap bathrooms, a stage, 2 walls that were altered, electrical and plumbing work, all done without obtaining permits. During the investigation, I took photographs of the property on April 21st, June 20th, April 26th, August 24th, and October 24th, 2016. These photos fairly and accurately represent the conditions I observed. I would like to offer the photographs and other supporting documentation into evidence as County Composite Exhibit Number 1.
Okay, those have been marked as Charlotte County Exhibit Composite 1 and admitted into evidence.
Courtesy letters were sent to the owner's address outlining the violations and allowing 30 days for compliance. I've had contact with the owner and explained to them that the violation still existed and must be taken care of to avoid further code action. Notice of violation was served in accordance with Florida Statute 162. On October 26, 2016, conducted the final inspection, finding the violation still existed. This concludes my testimony.
Thank you, Officer. Anything further?
The county recommends the respondent be found in violation of the code sections listed in the notice of violation, and from the date of this order, 30 days to apply for and obtain all necessary permits and pass all inspections in accordance with the Florida Building Code, or obtain a demolition permit and restore the property to its original condition, or thereafter face a fine of $100 per day for each day a violation exists.
Thank you. In Charlotte County versus Levi Holding LLC, COD 16320, pertaining to 3151 Cooper Street, units 51, 52, 53, 54, 55, and 56. I thought the evidence establishes the existence of the charges set forth in the notice of violation, and I accept the county's recommendation as my order. Agenda item B, case COD 162385, Curie and Smith Properties. If you're in that case, please approach. I note that no one is present on behalf of the respondent. If the county is ready to proceed, please call its first witness.
Officer DeShane.
Andre DeShane, Certified Code Enforcement Officer, Charlotte County. 1908 South McCall Road is zoned Commercial General. The owner of record is Curry and Smith Properties, Incorporated. On August 16, 2016, I conducted an inspection of the address and observed the following violations of vehicles offered for sale in the right-of-way and feather flags in the right-of-way. During the investigation, I took photographs of the property on August 16th, September 6th, and October 24th, 2016. These photos fairly and accurately represent the conditions I observed. I would like to offer the photographs into evidence as County Composite Exhibit Number 1.
Those have been marked Charlotte County Composite Exhibit 1, admitted into evidence. Please proceed.
Courtesy letters were sent to the owner's address outlining the violations and allowing 10 days for compliance. I have had contact with the owner's representatives and explained to them that the violations still existed and must be taken care of to avoid further code action. Notice of violation was served in accordance with Florida Statute 162. On October 24, 2016, I conducted the final inspection, finding that the violations still existed. This concludes my testimony.
The owner's representative,
It's like a sales manager type person who dealt with these issues.
Bad attitude, or did he just not respond? Or
no, I had conversations with him, and he was going to take care of the issue, and he did take care of a lot of it, because if you noticed here in the photograph where the green is, where the Cedar Road sign is, they used to be all full with vehicles and feather flags out in the right-of-way. But unfortunately, the yellow convertible, that the Mustang, and the car next to it is still in the right-of-way.
And the county's recommendation, if it has no further witnesses?
The county recommends respondent be found in violation of the code sections listed in the notice of violation, and from the date of this order, a 2-year cease and desist order for any future zoning violations, 15 days to clear the zoning violations, and 30 days to apply for and obtain all necessary permits, or thereafter face a fine of $100 per day for each day a violation exists, abatement in the event of non-compliance, and cost of abatement to be added to the fines and costs.
Thank you. Charlotte County versus Curry and Smith Properties, COD case 16-2385, pertaining to the property at 1908 South McCall Road, Inglewood, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation, and I accept the county's recommendation as my order. Takes us to case D on the agenda, David, COD 16-2192, Equity Trust Financial LLC. If you're present on that case, please approach. I note that no one is present on behalf of the respondent. If the county is ready to proceed, call its first witness.
And I'd like to note the county would like to dismiss sections 2-5-72, 3-9-33, sub E, and 3-9-76 Charlotte County Code.
Okay, motion granted.
Thank you. Officer Leonard.
My name is Rhonda Leonard. I'm a certified code enforcement officer for Charlotte County. 21146 Meehan Avenue is owned by Equity Trust Financial LLC and is zoned RSF 3.5. On July 18th, I conducted an inspection at the property and found the following violation of outside storage, furniture, trash, buckets, tarps, lawnmower parts, and assorted other debris. During the course of the investigation, I took photographs of the property on August 10th, August 16th, September 27th, and October 26th. These photos fairly and accurately represent the conditions I observed. I'd like to offer the photographs into evidence as County Composite Exhibit 1.
Those are so marked and admitted. Please proceed.
A warning letter was sent to the owner giving 10 days to comply. An inspection on August 10th found the outside storage remained. There was also an unlicensed white pickup in the front lawn, an unlicensed trailer in the side yard with no tag, and glass missing from windows. Another inspection on August 16th found no change in pre-existing conditions, and there was also high grass. Notice of violation, notice of hearing was sent certified mail and was served in accordance with Chapter 162 of the Florida statutes. A re-inspection on September 26th found the grass cut, the outside storage removed, and unlicensed vehicles removed. I spoke to a Nicholas of Equity Trust. He told me they had ordered windows. I advised I would continue the case to November to give him time to either repair or replace the windows, and that replacement would require a permit. I conducted the final inspection on October 26th, finding the windows have not been repaired, and I reviewed permitting, and they have not applied for a permit either.
Thank you. County's recommendation, if it has nothing further.
The county recommends respondent be found in violation of the code sections listed in the notice of violation as amended, and from the date of this order, 30 days to apply for and obtain all necessary permits, pass all inspections, and bring the property into compliance with the International Property Maintenance Code, or thereafter face a fine of $100 per day for each day a violation exists.
Thank you. Charlotte County versus Equity Trust Financial LLC, KCOD 16-2192, pertaining to parcels 40221517719. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation, and will accept the county recommendation as my order. Agenda case E, COD 16-2218, Federal National Mortgage Association. If anyone is here on behalf of the respondent, please approach. I note that no one is present on behalf of the respondent, so if the county is ready to proceed, call your first witness, please.
Officer Leonard.
My name is Rhonda Leonard. I'm a certified code enforcement officer for Charlotte County. 2135 Floyd Court in Port Charlotte is zoned RSF 3.5 and is owned by Federal National Mortgage Association. In reviewing previous case, COD-13-00620, I noted the property had gone through foreclosure and was now owned by the bank. A review of permitting found a driveway permit 2014-060-9289 still remains expired since January 25th of 2015. Site inspection found violations from the previous case had not been corrected and include unprotected and damaged exterior walls, damaged exterior windowsill, unprotected exterior door frame on the carport side, screens missing from windows, windows screwed shut, bedroom windows unopenable, creating a means of egress safety issue, exposed wiring, missing hardware on most windows, the kitchen sink dispersing water onto the ground with alterations done without a permit, and the driveway partially removed, leaving a trip hazard at the top and near the sidewalk. During the course of the investigation, I took photographs on July 19th, September 8th, and October 28th. These photos fairly and accurately represent the conditions I observed. I would like to offer the photographs and complete permit history into evidence as County Composite Exhibit 1.
Those are so marked and admitted. Please proceed.
A warning letter was sent to the owner, giving 30 days to comply. The notice of violation, notice of hearing was sent certified mail and was served in accordance with Chapter 162 of the Florida statutes. I conducted the final inspection on October 28th and reviewed permitting, finding the permit remains expired and conditions at the property remained unchanged.
Anything further from the county? If not, its recommendation.
The county recommends respondent be found in violation of the code sections listed in the notice of violation, and from the date of this order, 30 days to renew the expired permit and apply for and obtain all necessary permits, pass all inspections in accordance with the Florida Building Code, and bring the property into compliance with the International Property Maintenance Code, or thereafter face a fine of $100 per day for each day a violation exists.
Thank you. In Charlotte County versus Federal National Mortgage Association, COD 162218, pertaining to parcel 4022141800011. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation and have accepted the county's recommendations by order. Agenda item F, COD 162893, Tenny I. and Anastasia Fragadakis. I note no one is present on behalf of the respondent, so if the county is ready to proceed.
Officer Leonard.
My name is Rhonda Leonard. I'm a certified code enforcement officer for Charlotte County. 21431 Midway Boulevard is owned by Anastasia Fragidakis and Tenny I. Fragidakis and is zoned RSF 3.5. On September 14th, I conducted inspection at the property and found the following violation of excessive growth of grass and weeds and outside storage of miscellaneous items including trash, furniture, paintings, refrigerator parts, and assorted other debris, creating a junk-like condition and prohibited use of the property. A notice of public nuisance was posted at that time for the high grass. During the course of the investigation, I took photographs of the property on September 14th and on October 31st. These photos fairly and accurately represent the conditions I observed. I would like to offer the photographs into evidence as County Composite Exhibit 1.
So marked and admitted.
The notice of violation, notice of hearing was sent certified mail and was served in accordance with Florida Chapter 162 of the Florida statutes. Wow. The case was prepared as a repeat violator due to a previous case for the same violations in which the cease and desist order expired September 3rd. I conducted the final inspection on October 31st. The grass was cut through the NPN process on October 7th, is near violation again, and the outside storage remains. That concludes my testimony.
County's recommendation, please.
The county recommends respondents be found in violation of the code sections listed in the notice of violation, and from the date of this order, a 5-year cease and desist order for any future zoning violations and 15 days to clear the zoning violations, or thereafter face a fine of $50 per day for each day a violation exists, abatement in the event of noncompliance, and costs of abatement to be added to the fines and costs.
Thank you. Charlotte County versus Teddy Fragadakis, is that how you pronounce it? Whatever.
Fragidakis. I know, I had a hard time at first, too.
Well, if I've offended them, I apologize. But case number COD 162893, parcel ID 402215276002. I find that the charges set forth in the notice of violation have been established by the undisputed evidence, and I'll accept the county's recommendation as my order. Everybody okay proceeding through the lunch hour?
We are if you are.
I just assume keep going. I don't need to eat anyway. I'll take us to agenda item H, COD 161439, Edgar and Louise Hansen. I note that no one is present on behalf of the respondent, so if the county is ready to proceed, its first witness.
Officer Nicolosi.
Darcy Nicolosi, Certified Code Enforcement Officer for Charlotte County. The property in violation is located at 1230 Shoreview Drive and is zoned MMF12. The owner of record is Edgar and Louise Hansen. On April 15th, I conducted an inspection, finding a fence installed on the property. A review of the Charlotte County database found the permit had not been issued for the fence. A letter was sent on May 4th to the owner, giving 30 days to comply. During the investigation, I took photographs of the property on June 8th and October 31st. These photos fairly and accurately represent the conditions I observed. I would like to offer the photographs into evidence as County Composite Exhibit 1.
Those who have been so marked and admitted, please continue.
The notice of violation was served in accordance with Florida Statute 162. The respondent was given 10 days to come into compliance, reference the existing violations. Permit 2016-09-17542 for the fence has been ready for pickup since October 19th. I have contacted the contractor several times to get the permit issued. On October 31st, I conducted the final inspection, finding the conditions remained the same as evidenced in the photographs. A review of the database found the permit still ready for pickup. This concludes my testimony.
Thank you. If the county recommendation, please.
The county recommends respondents be found in violation of the code sections listed in the notice of violation, and from the date of this order, 15 days to clear the zoning violations, apply for and obtain all necessary permits, and pass all inspections, or remove the fence and restore the property to its original condition, or thereafter face a fine of $100 per day for each day a violation exists.
Thank you. Charlotte County versus Edgar and Louise Hanson, COD 16-1439, pertaining to parcel 1230 Shoreview Drive, Englewood, Florida. Find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation, and that I accept the county's recommendation as my order. Takes us to agenda item I, COD 16-2545, Kenya A., Richard L., and Nina Denny. I note that no one is present on behalf of the respondent, so if the county is ready to proceed, its first witness, please.
Officer Nicolosi.
Darcy Nicolosi, Certified Code Enforcement Officer for Charlotte County. The property in violation is located at 10502 Houston Avenue and is zoned RSF 3.5. The owner of record is Kina, Richard, and Nina Denny. On August 19th, based upon a complaint, I conducted an inspection of the address and observed the following violations: 3 unlicensed vehicles, an unlicensed boat trailer, all with expired tags, outside storage of planting pots, wood, wheelbarrow, blue container, and assorted other debris, property overgrown with weeds and bushes, front door was open and the front door was open. A letter to the owner was sent giving 15 days to comply. During the investigation, I took photographs of the property on September 8th, October 6th, and October 26th. These photos fairly and accurately represent the conditions I observed. I would like to offer the photographs into evidence as County Composite Exhibit 1.
So marked and admitted, please proceed.
On September 8th, I contacted the Sheriff's Department to meet me on site for the reinspection to check the residence and lock it back up. The notice of violation was served in accordance with Florida Statute 162, posting on October 6th. On October 26th, I conducted the final inspection, finding conditions remained the same as evidenced in the photograph. This concludes my testimony.
If the county has nothing further, its recommendation, please.
The county recommends respondents be found in violation of the code sections listed in the notice of violation, and from the date of this order, a 2-year cease and desist order for any future zoning violations, and 15 days to clear the zoning violations and bring the property into compliance with International Property Maintenance Code, or thereafter face a fine of $50 per day for each day a violation exists, abatement in the event of noncompliance, and costs of abatement to be added to the fines and costs.
Thank you. Charlotte County versus Denny, COD 16-2545. Parcel ID 4120022260012. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation, and I have accepted the county's recommendation as my order. Takes us to case agenda K, Joseph Weaver, 16-2492. I note that no one is present on behalf of the respondent, So if the county's ready to proceed, I guess Officer Brown's up.
Yes, Officer Brown.
Stephen Brown, Certified Code Enforcement Officer for Charlotte County. 19266 Edgewater Drive is zoned RSF 3.5. The owner of record is Joseph H. Weaver. August 12, 2016. I initiated the case finding outside storage in junk-like conditions, including but not limited to wood, metal, tires, plastic, and the property was overgrown with grass and weeds. Photos. September 8, 2016. Site inspection, finding the violations still remain. Photos. November 1st, 2016. Site inspection, outside storage, creating junk-like conditions still remain. Photos. During the investigation, I took photographs of the property on August the 12th, 2016, September the 8th, 2016, and November the 1st, 2016. These photos fairly and accurately represent the conditions I observed. I'd like to offer the photographs and the evidence as County Composite Exhibit 1.
So marked and admitted.
The notice of violation was served in accordance with Florida Statute 162. I have had contact with the owner, explaining the violations to him and what needed to be done to bring the property into compliance. This concludes my testimony. But one more thing. I will say, though, when I did my visit on the 1st, he did have the property fully mowed. So I guess we would have to get rid of the 2572.
Officer Brown, was the grass in violation more than 10 days after the notice of violation was served?
Yes, ma'am.
Thank you. Yep. We just have the record. Did you have anything further?
No, ma'am.
Any county's recommendation then?
The county recommends respondent be found in violation of the code sections listed in the notice of violation, and from the date of this order, a 2-year cease and desist order for any future zoning violations and 15 days to clear the zoning violations, or thereafter face a fine of $50 per day for each day a violation exists. Abatement in the event of noncompliance, and costs of abatement to be added to the fines and costs.
I hate to hit them for the yard, but I mean, they're not even here to defend themselves.
Well, it took right up into right before the hearing, before he actually had the yard mowed fully, so.
All right, Charlotte County versus Joseph Weaver, COD 16-2492, related to property at 19266 Edgewater Drive in Port Charlotte. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation and accept the county recommendation as my order. I think that take us to case in.
Yes, sir.
Okay. COD 152284, Robert Stickney, revocable trust. I note that no one is present on behalf of the respondent, so if the county is ready to proceed as first witness.
Officer Moore.
Renell Moore, Certified Code Enforcement Officer for Charlotte County. 2725 Magnolia Way is zoned MHC, Mobile Home Conventional. The owner of record is Robert W. Stickney and Joanne A. Stickney, trustees. This case was initiated by myself July 11, 2016, when I conducted an inspection of the address and observed the following violations: an expired permit for an irrigation system. Courtesy letters were sent to the owner's address outlining the violations and allowing 30 days for compliance. During the investigation, I took photographs of the property on July 11, 2016 and October 26, 2016. These photos I would like to offer. These photos fairly and accurately represent the conditions I observed. I would like to offer the photographs into evidence as County Composite Exhibit 1.
So marked and admitted.
The notice of violation was served in accordance with Florida Statute 162. I've had contact with the owner on or around August 15, 2016 by phone. She requested a continuance because they would not be in the state until October. This continuance was granted. On October 26, 2016, I conducted the final inspection, finding that the violations still exist. This concludes my testimony.
Had the owners returned when you were there on October 26th?
It appeared they had returned, yes.
They've not contacted you or anything since that time?
No. No, Your Honor.
Thank you. County recommendation then?
The county recommends respondents be found in violation of the code sections listed in the notice of violation, and from the date of this order, 30 days to renew the expired permit and pass all inspections in accordance with the Florida Building Code, or thereafter face a fine of $50 per day for each day a violation exists.
Thank you. Charlotte County versus Robert W. Stickney Revocable Trust, COD 152284, related to parcel located at 2725 Magnolia Way, Punta Gorda, Florida. Find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation, and I've accepted the county's recommendation as my order. Agenda item O, 16-370, Gerald Squires. I note that no one is present on behalf of the respondent. The county is ready to proceed. Your first witness.
Officer Moore?
Renell Moore, Certified Code Enforcement Officer for Charlotte County. 6816 Bernardine Boulevard is zoned MHC Mobile Home Conventional. The owner of record is Gerald E. Squires. This case was initiated by myself June 14, 2016, when I conducted an inspection of the address and observed the following violations: excessive growth of grass and weeds or other vegetative growth exceeding 12 inches in height and encompassing more than 50% of the mobile lot, torn lanai screens, and a wooden porch in disrepair. Courtesy letters were sent to the owner's address outlining the violations and allowing 30 days for compliance. During the investigation, I took photographs of the property on June 14, 2016 and October 21, 2016. These photos fairly and accurately represent the conditions I observed. I would like to offer the photographs and evidence as County Composite Exhibit 1.
So marked and admitted.
The notice of violation was served in accordance with Florida Statute 162. I have had no contact with the owner. On October 21, 2016, I conducted the final inspection, finding that the violations still exist. This concludes my testimony.
Thank you. Does the county have a recommendation?
The county recommends respondent be found in violation of the code sections listed in the notice of violation, and from the date of this order, a 2-year cease and desist order for any future zoning violations, 15 days to clear the zoning violations, and 30 days to bring the property into compliance with International Property Maintenance Code, or thereafter face a fine of $50 per day for each day a violation exists, abatement in the event of non-compliance, and cost of abatement to be added to the fines and costs.
Thank you. Charlotte County versus Gerald Squires, COD 16370, pertaining to parcel at 6816 Bernardine Boulevard, Punta Gorda, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation, and will accept the county recommendation. I'm sorry.
Oh, Q.
Order. Takes us to that was funny. All right, agenda item Q, case 16-1308, Paul Whippert. I know no one is present on behalf of the respondents, so if the county is ready to proceed, its first witness.
Officer Moore?
Renell Moore, Certified Code Enforcement Officer, Charlotte County. 3651 Dawson Lane is zoned RSF 5, residential single family, 5 units per acre. The owner of record is Paul Whippert. This case was initiated by myself August 16, 2016, when I conducted an inspection of the address and observed the following violations: of an accessory structure on a vacant lot, excessive growth of grass and weeds, or other vegetative growth exceeding 12 inches in height and encompassing more than 50% of the mowable lot, and prohibited use of the property. The courtesy letter was sent to the owner's address outlining the violations and allowing 30 days for compliance. During the investigation, I took photographs of the property on August 16, 2016 and October 19, 2016. These photos fairly and accurately represent the conditions I observed. I would like to offer the photographs into evidence as County Composite 1.
So marked and admitted.
The notice of violation was served in accordance with Florida Statute 162. I have had no contact with the owner. On October 19, 2016, I conducted the final inspection, finding that the violations still existed. This concludes my testimony.
County's recommendation, please.
The county recommends respondent be found in violation of the code sections listed in the notice of violation, and from the date of this order, a 2-year cease and desist order for any future zoning violations and 15 days to clear the zoning violations, or thereafter face a fine of $50 per day for each day a violation exists. Abatement in the event of noncompliance, and costs of abatement to be added to the fines and costs.
Thank you. Charlotte County versus Paul Whippert, COD 16-1308, pertaining to the parcel located at 3651 Dawson Lane, Punta Gorda, Florida. I find that the undisputed evidence establishes the charges that are set forth in a notice of violation, and I accept the county's recommendation as my order. Okay. Agenda item R, 2345, Margot Air. I note that no one is present on behalf of the respondent, so if the county is ready to proceed as first witness.
Officer Moore.
Rennell Moore, Certified Code Enforcement Officer for Charlotte County. 11126 Grapefruit Lane is zoned MHC, Mobile Home Conventional. The owner of record is Margot Air. This case was initiated by myself September 12, 2016, when I conducted an inspection of the address and observed the following violations: a mobile home placed on the property without a permit and prohibited use of the property. A code compliance request was left at the address outlining the violations and allowing 30 days for compliance. During the investigation, I took photographs of the property on September 12, 2016 and October 19, 2016. These photos fairly and accurately represent the conditions I observed. I would like to offer the photographs and evidence as County Composite Exhibit 1.
So marked and admitted.
The notice of violation was served in accordance with Florida Statute 162. I've had no contact with the owner. On October 19, 2016, I conducted the final inspection, finding that the violations still exist. This concludes my testimony.
Thank you. If the county doesn't have anything further, its recommendation, please.
The county recommends respondent be found in violation of the code sections listed in the notice of violation, and from the date of this order, 30 days to renew the expired permit and pass all inspections in accordance with the Florida Building Code, or thereafter face a fine of $100 per day for each day a violation exists.
Thank you. Charlotte County versus Margot Air, COD 16-2345, pertaining to parcel located at 11126 Grapefruit Lane, Punta Gorda, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation, and accept the county's recommendation as my order. T. Maybe we have two more. Okay. Agenda item T, COD 16-2276, Equity Trust Company, for use and benefit of Dennis Kurza, IRA. I note that no one is present on behalf of the respondent, so if the county is ready to proceed, please call your first witness.
Officer LaRue.
Chris LaRue, Certified Code Enforcement Officer for Charlotte County. 3540 Idlewild Street is zoned residential single family 3.5. The owner of record is Equity Trust Company, custodian, FBO, Dennis Lee Kazara, IRA. On July 27, 2016, I conducted an inspection of the property and found outside storage in junk-like conditions consisting of, but not limited to, pallets of tile, a woodworking bench, commercial power tools, creating a junk-like condition, and prohibited use of the property. Code compliance request was left at the property on July 27, 2016, and a warning letter was mailed on August 9, 2016, to the owner outlining the violations. During the investigation, I took photographs on August 9th, September 9th, October 28th, and November 1st. These photographs fairly and accurately represent the conditions I observed. I would like to offer these photographs into evidence as County Composite Exhibit Number 1.
So marked and admitted. Please proceed.
Notice of violation was served in accordance with Florida law, Statute 162. I have had personal contact with the owner of the property on August 23rd, where he advised that he would clear the violations. I conducted an inspection on November 1st, 2016. Final inspection finding violations still exist. This concludes my testimony.
County's recommendation, please.
The county recommends respondent be found in violation of the code sections listed in the notice of violation, and from the date of this order, a 2-year cease and desist order for any future zoning violations and 15 days to clear the zoning violations, or thereafter face a fine of $100 per day for each day a violation exists, abatement in the event of noncompliance, and cost of abatement to be added to the fines and costs.
Thank you. Charlotte County versus Equity Trust Company, COD 162276, pertaining to the parcel located at 3540 Idlewild Street, Port Charlotte, Florida. I find that the undisputed evidence establishes the charges set forth in the notice of violation and have accepted the county recommendation as my order. I think that takes us to our last case, U, on the agenda. COD 162894, Robert and Bunny Motzer. I note that no one is present on behalf of the respondent, so if the county is ready to proceed, its first witness, please.
Officer LaRue.
Chris LaRue, Charlotte County Code Enforcement Officer. 143 Rogers Avenue is zoned residential single family 3.5. The owner of record is Robert G. and Bunny S. Motzer. On September 15th, 2016, I conducted an inspection of the property, finding junk-like conditions consisting of, but not limited to, tires, jack stands, power cords, yard tools, a section of fence, inoperable vehicle, and other items causing a junk-like condition, prohibited use of the property. During the investigation, I took photographs on September 15th, October 28th, and November 1st. These photographs fairly and accurately represent the conditions I observed. I would like to offer these photographs into evidence as County Composite Exhibit Number 1.
So marked and admitted.
Notice of violation was served in accordance with Florida Statute 162. The case was prepared as a repeat violator due to a previous case for the same violations, which the cease and desist order expired on October 3rd, 2015. I've had personal contact with the property only on one occasion. On November 1st, 2016, I conducted my final inspection, finding all the violations still exist. This concludes my testimony.
There's nothing else from the county. Its recommendation, please.
The county recommends respondents be found in violation of the code sections listed in the notice of violation, and from the date of this order, a 5-year cease and desist order for any future zoning violations and 15 days to clear the zoning violations, or thereafter face a fine of $50 per day for each day a violation exists, abatement in the event of noncompliance, and cost of abatement to be added to the fines and costs.
Thank you. Charlotte County versus Robert Motzer, Adux, COD 162894. Pertaining to the parcel of property located at 143 Rogers Avenue, Port Charlotte, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation and accept the county's recommendation as my order. Just want to confirm that covers the new business agenda.
That's everything we have.
All right, so that takes us to agenda item 11, staff and citizen input. None. Then we are adjourned.